Hello and welcome to today's event. We're delighted that you can join us today. We're going to be discussing AI, artificial intelligence, and we're joined today organising this conference by the Open Society European Policy Institute and European Digital Rights Organisation. Now, AI means different things to different people, from algorithmic decision making to machine learning and even predictive text on your phone. And Hollywood movies, of course, from 2001: A Space Odyssey to The Terminator, have taught us that we need to be afraid of this technology, which isn't really the case, at least not for the reasons those films suggest. Unfortunately, all our concerns should be based on what the humans behind the technologies are doing. The danger really is that those who are worst off in society, the really disadvantaged, end up even worse off. So the EU is trying to regulate this to prevent systemic injustice. And we here in Europe pride ourselves on exporting laws. The General Data Protection Regulation, the GDPR, is often cited as a prime example of the rest of the world following our lead. But that just puts even more pressure and more responsibility on us to make sure that we are exporting the right laws. Now, the AI Act is going to try and tackle a lot of the systemic problems we talk about, but is it doing it in the right way? That's the question we're going to be asking today, with a focus on social justice and anti-discrimination. So we have a great lot of panels lined up for you today. We're going to be going through to 4 o'clock this afternoon. My name's Jennifer Baker. I'm a tech policy journalist, and I'll be your moderator today, putting your questions to our panelists in those various sections. So make sure you write them down in the chat box and keep them clear, keep them succinct, and if they're for a specific panelist, please do say that so that we can know who to direct your questions at, because we really want this to be a wide-ranging discussion where we try and come up with solutions to the problems rather than just identify the problems, although of course we will try to do that as well. But that's enough for me. To open up our event today, I'm going to hand over to Pamela Valenti, who is the Senior Associate Policy Officer at the Open Society European Policy Institute, and she is one of the organisers of today's programme, Pamela. So over to you. Tell us why it's so important, what's happening at EU level, and why is it these issues so important to us?
Thank you, Jen, for the great introduction, and to the entire Euractiv team for hosting us today. Good morning, everyone, and thank you for joining us to discuss how the regulation on artificial intelligence should address discrimination and surveillance in Europe. My name is Pamela Valenti, and I work on digital policy at the Open Society European Policy Institute, the EU policy and advocacy arm of the Open Society Foundations in Brussels. OSEPI is one of the largest private foundations supporting groups and individuals all around the world to promote justice, human rights, and inclusive democracy. We are organizing this conference today together with European Digital Rights, a long-standing partner of the Open Society Foundations and the biggest network of NGOs working to advance digital rights in Europe. You will hear more about EDRi from Sarah and Claire in the second half of the conference, but let me thank you all already for being here on behalf of both organizers. We are here today to understand whether the rules that the European Commission has set out in the Artificial Intelligence Act are enough to protect fundamental rights, especially when we look at the rights of those in our society who suffer from racial discrimination and systemic injustice. 2022 is a watershed moment for the regulation of technology. The draft AI regulation, which is set to be the first binding legal framework on the use of artificial intelligence across Europe, is currently being discussed and negotiated both in the Council of the EU and in the European Parliament. The Commission proposals that came out last April already prohibited some of the most dangerous uses of AI and set out requirements for other uses that are considered as high risk. Now is the time for the co-legislators to go further and to decide on what more needs to be done in order to protect people from discrimination and injustice. Artificial intelligence and automated technologies are increasingly used in areas of the public sector such as law enforcement, policing, employment, social welfare, and migration. However, none of these technologies is neutral or scientifically objective. Organizations like EDRi and many other partners of the Open Society Foundations have long investigated how pre-existing biases and discrimination become hardwired into artificial intelligence, and how this technology in return often perpetuates and amplifies systemic racism and structural discrimination that already oppress the most marginalized in the offline world, such as racialized communities, people on the move, LGBTQIA+ people, persons with disabilities, and people from the working class. Our intention today is to bring together civil society and policymakers with those who have a lived experience of technological discrimination and surveillance to discuss how the regulation on artificial intelligence can be improved to deliver fundamental rights and social justice for all. The 4 panels today will address some of the core issues at the heart of this debate. The first one will look into discriminatory uses of AI by law enforcement in EU member states. Speakers will discuss why profiling and predictive technologies mostly target people from racialized communities and the working class, and will outline how the regulation on artificial intelligence should be changed to safeguard the right to fair trial and the presumption of innocence in policing and criminal justice. The second panel will look at the situation of gig drivers and couriers whose work is managed and controlled by algorithms, and we'll discuss the impact of automated management on workers' rights and social protection in the platform economy. The panel will also explore how social welfare is increasingly allocated and distributed through profiling tools, predictive technologies, and scoring systems, and will assess the impact of this automation on people in need of social support. The third panel will instead show us how countries in the European Union are experimenting with migration management technologies on asylum seekers and people on the move. These technologies are tested and used on migrants for the purpose of data mining and border enforcement, with no meaningful consideration for people's lives and rights. Our speakers will also discuss how these technologies play out specifically for undocumented people and whether the regulation on AI does enough to protect their fundamental rights. Finally, the last panel will draw lessons from the previous discussions and assess how the European Union should position itself in this debate in order to protect human rights and social justice through the Artificial Intelligence Act. We are thrilled to welcome such an exciting group of speakers today, and we look forward to hearing directly from them. But before passing the floor to Jennifer to kickstart the discussion, without further ado, let me thank my colleague Mariana Liana Donaki from OSEPI and Tamara Novel and Elisa Colum from Euractiv for making this event possible in the first place. Thank you very much, Jen. Over to you.
Thank you very much, Pamela. That's a great introduction to our day. As you say, those panels that we're going to look at, the 3 thematic panels, are really very key areas where we do see discrimination happening. And also, as you pointed out, targeting the most vulnerable, which is, of course, something we want to address. So with that, I'm going to introduce you to our first panel. We're talking about discriminatory surveillance in law enforcement and criminal justice. Now, this is an area where, of course, private individuals have very little comeback. I mean, we have the laws to allow redress, but they are at the end of this chain of legal terms and legal situations. So at the end of the day, this is something that really can impact on everyone, because you do not know when you may be the subject of injustice. But we're going to look at those who are most vulnerable. We're going to look at systemic problems in the justice system across the EU. And of course, we'll draw examples from around the world as well. First of all, let me introduce Diana Sarjo, a mother whose child was targeted by risk modelling and profile systems used by the Amsterdam police. And as a result, she took matters into her own hands and founded an NGO. The mother is the key. I won't say it in Dutch because my Dutch is terrible, but thank you very much, Diana. I know that your platform is for mothers and care professionals to share their experiences and to try and create an inclusive support system for at-risk youth. Now, Laure Bordier-Gérard is the legal director for Europe of Fair Trials, which is an international human rights NGO that campaigns for fair and equal criminal justice systems. And in September 2021, last year, Fair Trials published Automating Injustice, a report that examined the AI, the use of artificial intelligence systems in criminal justice in Europe, how they were created, what they're used for, and their direct impact on people and rights. And again, we look further afield as well to draw examples from around the world on where these systems can go wrong. And last, but by no means least, we are very pleased to have joining us from the European Parliament, Bernardo Barena Alza, who is with the Left, the GUE group in the Parliament. He's a member of the Committee of Civil Liberties, the LIBE Committee, and a substitute member in the Special Committee on Artificial Intelligence in a Digital Age, the AIDA Committee, that we will hear referred to a lot during today. Thank you all very much for being with us. Diana, let me start with you. Tell us about your experiences, your motivations, and what you would like to see in the law that's forthcoming, because at the end of the day, that is what we want to see come out of today's discussions. Some real suggestions.
Well, thank you, Jennifer, for having me. My experience, I didn't realize I was targeted, my sons neither. And the moment I realized it is after it all happened to me, I start thinking from how did my sons get on the list? Who is the one who's deciding that my son is on the list? Because they say, yeah, he's this, he's that. But I started to think from How did he get there? So I started to do my own research, and I have a banking background, and so numbers is my thing. So I start searching for reports, and I was reading those reports, and I said that something ain't right because the numbers didn't add up in my head. And I started looking for it and started to translate the numbers to my real life because I know the use of algorithm, but I only knew using it in a bank and those kind of stuff. I didn't know they were using it at people. And in real life, we people from low from, let's say, how do you say, from areas where a lot of different cultures are together, they don't stand a chance. They will be targeted. The children are targeted from baby because first you go to get their shots. They decide how your baby's growing. Is he growing fast enough? Things like that, and it all adds up. They go to school. They ask you questions like, parents, do you speak Dutch? If you say, yeah, I speak Dutch, then they say, where are your parents from? Where's the grandmother from? So all this information gets into a system. And if your child doesn't fit in what they designed from this is the perfect child, you're already at risk. And if it's your social status, if you're single mom, if you have a black background, and things like that. And the first thing start when my son was 11 and he was coming home from a friend, and I was watching out of the window, and I saw a group of white young kids walking and making noise, things like that. And my son was walking alone, and they stopped him and they asked him for papers. I'm like, I was yelling out the window, he's only 11. But I didn't know that that was the first encounter they registered. And after that, I saw more things happening, but I was like, from now, it will go. And then it started to get worse and worse. It's like a self-fulfilling prophecy because they create circumstances for those boys that they will commit petty crime and that will be registered. And then they already have a high risk profile. And that was the craziest stuff that I ever met. I was like, something ain't right. You can beat, artificial intelligence cannot beat a mom's intuition. I stand by that. And I kept searching. I was like, huh? So I started a foundation after my whole period. I was thinking, from how do they get to the information from the boys? Where do they get it from? Because some of the boys don't stand a chance and they were not even fitting the profile of a boy of the 400 or the 600. But somehow somebody is providing this information before they get there. So I learned about ProKit, and ProKit is when the police is making a report about your child when he gets an encounter with the police. And I started to ask him for my files, and I wanted to know what's in it. And if I knew this before, I would be more consistent on asking for this information. Because when I read it, it didn't match reality. Because the things they wrote about me and my family weren't correct. And I cannot change that. And that is something that hurt me, because if it happens to me, it happens to a lot of families. Because when I start talking to different mothers, and the thing we had in common, because I started a foundation based on only crime, children who are in encounter with the police or justice or went to jail and things like that, who are at risk of falling out of society. And then I noticed one thing, even when I had a white mother and I saw her son, and the son was biracial, he was on the list too. But when I had a mother whose son was not biracial, the report was different. It was softer, kinder, and that boy had more chances than the boy with an ethnical background. And that's something that concerned me. Because if you're using those systems to target our boys, or to, let's say, help, because that's still something we have to talk about. And we're using those systems to give, yeah, to make reports, and we say this is true. I can tell you, you can throw all the reports away and start all over again, because the reports don't match reality. And I don't know whose idea it was that only based on a report you can target a kid. because the kid also has an environment. The kid has also feelings. The family has also feelings. There are too many families destroyed about through the system, and I don't know why. I don't know what the reason is. I still want to find out what the reason is and who's controlling those systems. Because if I ask for a question and I start about the use of algorithm, everybody's quiet. I search on the internet, I can hardly find anything about the use of those systems because nobody's honest to us with parents because we are fighting the reality. But on the other side, you feel like a mother that something ain't right from how do they get our information? And I think it starts at birth. And they start collecting all our information, put it in a system, and they think that is right. And we need to change that. And I don't know whose idea it is to use the artificial intelligence right now, or facial recognition, because that also is a problem. Because let's say my two sons, yeah, one son has an iPhone. They open their iPhones with facial recognition. But if his brother takes the phone, he can open the phone also. So who's going to decide on which kind of facial recognition, what they're going to use? You know, what kind of how do you say it? I can find the word. Sorry, I'm Dutch. What kind of things they're going to use? Which color eyes? How they're going to recognize bone structure? Because facial recognition is different than DNA using. DNA comes from a human. That's unique. You know, even if you get a DNA from the brother, it will say it's not the person, but there will be a difference. But how are you going to do it with facial recognition? You cannot. I'm not I don't think it's a good idea to use artificial intelligence to fight crime. It's still something that needs to be done by humans with common sense, with real police work, not with cameras and things like that. You can use it maybe as a backup to find a car or anything like that, but with using it on people, I don't think it's a good idea. So
I think
that's where I
you've
stand.
very absolutely nailed it. I mean, a very strong, passionate opening to our discussions today, because I think you've pointed out the difference between using these metrics, these sort of arbitrary metrics that you don't know what they are, and using what the person in front of you is saying. So I think the systemic nature is coming through really strongly. I've got lots of questions I want to ask you straight away, Diana, but first I'm going to hand over to Laura. Laura, Fair Trials is looking at the sorts of experiences that Diana's had. So tell me a little bit about the examples that you've seen in different EU member states. We've heard from Diana what the situation is in the Netherlands, but I'm sure you're seeing it around the EU as well.
Thank you so much, Jennifer. Thank you. I'm very honored to be here today and share a platform with Diana and Fernando. Many thanks to OSEPI-EDRi for organizing this event, and Jennifer for the introduction. Let me just start by answering today's question on whether the EU AI Act can fix injustice by saying yes, it can. The EU can prevent future injustice provided it prohibits predictive and profiling systems in law enforcement and criminal justice, the systems that Diana just described being targeted by, and that are used to predict, profile, and assess people's risks or likelihood of future criminal behavior. And in addition to that, the EU AI Act needs to include strict safeguards around transparency and accountability for all types of AI and automated decision-making systems. Diana was very compelling in that difficulty in terms of accessing information about why this was happening to her and her sons, and that transparency is actually fundamental to create, to underpin a strong prohibition and strong legislation. So we very much want to see the EU take the lead here on setting the standard, and we're not alone in advocating for this. Earlier this month, together with 45 other organizations, including EDRi, we called on the EU to adopt such a ban. And Diana really showed us the extent of the harms caused by such systems that we are asking to be banned. She spoke of families being destroyed, of destinies artificially set from birth. She also talked about being entrapped in these systems. I mean, this account is incredibly powerful and needs to be addressed in law. And there are simply no safeguards that can protect people's fundamental rights against such harms. And nothing, not security, not innovation, can outweigh and justify such harm. And let me explain now how we reached this ask through the research that you mentioned, in particular, on the different systems in use already in Europe. So the basic premise is that criminal justice system is already causing harm, and artificial intelligence systems would just uncontrollably amplify the harm caused. Because as Diana said, her story is not alone, although her courage and the investigation she undertook single-handedly is exceptional. It was very difficult for us to even do this research and document the different examples of such systems already in place, in use across Europe. But what we've seen is that in various countries, the Netherlands in particular, also Spain, the UK, we see that policing is already obviously relying on the gathering of masses and masses of data. And then this data is processed and analyzed so that historical data can be used to make future predictions and can inform a criminal justice outcome or decision. And the idea behind the technology is that if you have information about how people from certain social groups or with certain backgrounds behave, then you can somehow predict how an individual within that group or with a similar background will likely behave in future, and use that to determine future criminality. But very concretely, and Diana very much described this, what data is being gathered in the systems we looked at. Of course, there's policing activity, so arrests, for instance, but there's also all sort, or the stop and search, like Diana described of her 11-year-old son, the identity check. All of that activity is data stemming from this activity is brought in. But then we also have all sorts of other data. We have policing data, for instance, in relation to victims, people who report being victims of offenses or close to a family member who has been a victim. Someone who is alleged to have associations with someone known to the police, for instance, will go into these databases. But also data that's not related to policing activity at all, like family status, very much like Diana described, people from a single parent family with an immigrant background or whose parent is in receipt of child benefits. So for example, in the system that we identified in the Netherlands, the police was working with social services to profile young men who are likely to commit crime in the future, based on whether they had previously been monitored by the police, even if they hadn't even been arrested for anything, based also on whether they'd been arrested, again, regardless of whether they'd actually been charged or convicted with anything, but also based on whether they had been in care or if they had not been present at school or had changed school. So there's a lot of data here that's coming in. And effectively, this data is used to create, to train, to operate these systems. And that what's happening is that these systems are reflecting the historical, the systemic, the institutional discrimination which results in racialized people, communities, and geographic areas being over-policed and disproportionately surveyed, questioned, and detained and imprisoned across Europe. So we need to shake off the image that technology is somehow neutral. It's not. And AI is replicating all forms of discrimination, racism, and bias. So for instance, in this top 400 system in the Netherlands that we mentioned earlier, 1/3 of the young men on the system had Moroccan heritage. And this is documented in our report. Another common example of how discrimination operates in this data is how seemingly neutral data can act for a proxy for other factors such as race and ethnicity, is the use of home address or area codes. And what we saw in our research is that AI systems will seek out correlations between area codes and risk of reoffending. And in other words, they will identify area codes that have a higher risk residence than others. But we know, again, this is not neutral. For example, Roma are vulnerable to this type of proxy discrimination because in many EU member states, they are reported to live primarily in segregated areas. And all of this has serious, significant effects on judicial outcomes, on the criminal justice process, creating, as Diana expressed, this self-fulfilling prophecy, this self-confirming bias where these decisions, these predictions really increasingly are used to influence and inform who gets monitored by the police, who gets stopped, who gets searched, who becomes a suspect then in a criminal proceeding. Because the use of these systems doesn't stop at policing. It's also used in bail, in prosecution decisions, and in pretrial detention decisions, in sentencing and in probation. And this we documented in Spain, for instance. And they can also lead, and it's very important to emphasize, on non-criminal justice punishment that have also severe consequences, such as the denial of welfare or other essential services, or even the removal of children from their families. And the issue, again, as Diana pointed out, is the lack of transparency, that even judges or other decision makers don't even often know how these predictions work, and the prejudicial assumptions and correlations that inform them. So, that's why if the EU now has this opportunity to act, and if it doesn't, these predictive systems will just further expand this net of criminalization, this entrapment of more and more people in the system, because these AI systems go in pair with policy responses to recourse to criminalization to solve any social situation. We just saw it recently again with the COVID-19 crisis, without any evidence that criminalization actually helps. And actually more and more evidence that criminalization does not help, it does not solve issues. So we are very concerned about how these systems are just going to hardwire discrimination that's already existing in criminal justice system and really increase the reach of this criminal law net and cause more and more harm. So to wrap up, I think this reason we are calling for a ban that needs to of these predictive systems, and a ban that needs to be underpinned by transparency rules to ensure that the prohibition is meaningfully enforced, and also by accountability mechanisms and the right to an effective remedy, because it is crucial that people affected by these systems and the outcomes of these systems are aware of their use, and have clear and effective routes to challenge them as quickly as possible, and not to be tracked in this surveillance net, or the uncertainty of knowing that they probably are trapped without any clear information or knowledge that prevents them from seeking redress and upholding their rights until it's too late for any meaningful redress. Thank you.
Thank you, Laura, and thank you for highlighting as well, not just the predictive policing aspect. I mean, many people are aware of facial recognition as a technology and that it may indeed be used by the police, but I think fewer are aware of things like sentencing software that actually tells judges what sort of sentences to hand down to people, which I think probably many judges would say is not even necessarily what they want either. So we're going to have to talk about this element of whether even the police forces themselves are becoming over-reliant on the technology, and whether they want it, whether it's helping them or whether it's actually becoming burdensome in actual criminal justice, which of course has to take place alongside it. Fernando, these are really strong stories we're hearing there from Diana and Laura. You're in the unenviable position in the LIBE committee of having to decide where the law gets involved in restricting overuse of technologies, while at the same time maybe taking advantage of the technology that we have out there that can maybe make police lives and more law enforcement's lives easier and better, and hopefully result in a better outcome. But where do you draw the line? How is the AI Act progressing? What's happening in the LIBE committee, and where are your main areas of concern at the moment?
Well, I have to say good morning, everybody. It's a pleasure to accept your kind invitation. First of all, I have to start clearly stating that many artificial intelligence technologies poses a number of serious risks to fundamental rights, gender equality, and racial discrimination. The widespread use of facial recognition technologies has particularly alarming consequences for critical human rights issues. fueling mass surveillance and racial profiling. According to the Commission, the European Commission white paper on artificial intelligence and European data protection rules, the processing of personal data for identifying a natural person is prohibited, except under specific conditions. And according to the GDPR, the General Data Protection Regulation, data processing should mainly take place for reasons of substantial public interest. We as a group share a common ground that under European Union or national law, the processing of personal data such as facial images by public authorities should not infringe on fundamental rights. The United Nations Human Rights Council has found that in the absence of robust rights protections, which are institutionally embedded to oversee the collection, storage, and use of such evidence, relevant practices are likely to infringe international human rights law standards. And along these facts, may I highlight the issue of facial recognition technologies. Facial recognition technologies will jeopardize a number of fundamental rights that are safeguarded under European law. For example, the respect for private life and personal data and the preservation of human dignity will be central to the deployment of facial recognition technology in public spaces. The processing of facial images will violate a person's right to privacy. The biggest problem with the most algorithms used in facial recognition technologies is the misidentification of non-white or non-male faces. Inaccuracy and misidentification of facial recognition for non-white groups by law enforcement authorities can lead to wrongful arrests, charges, and detention. And in Europe, a lack of regulation of such technologies will bring similar problems, exacerbating discrimination. The stance of the group I belong to, the group of the left in the European Parliament on this issue, is that to prevent an infringement of fundamental rights and guarantee privacy protection for all individuals, including migrants, women, and people of color, there should be a Europe-wide ban or moratorium on the use of facial recognition technology in public spaces. The Commission has made the development of artificial intelligence and related technologies a top priority, focusing solely on innovation and attracting tech investment in Europe. But I would say that as backed up by various studies on this issue, we should call for a ban or a moratorium, as facial recognition is prone to inaccuracy, discrimination, and identity fraud. As the left group in the Parliament, in the European Parliament, we demand a human-centered development of artificial intelligence technology in full compliance with the fundamental rights standards set out in law, and the promotion of social inclusion, sustainability, and fairness. The first step should be such a ban on facial recognition as the only way to preserve our dignity and rights. I want to stress that biometric facial recognition in public spaces is fully unacceptable. In principle, facial recognition should only be used to a limited extent in strictly regulated cases. Respect for fundamental rights is the measure of every constitutional state. We do not want the comparison of biometric facial features to gradually become the standard procedure for police work, and only what is technically feasible, the facilitation of police work, does not justify, according to our opinion, the automatic use of such a fundamentally invasive technology.
Thank you, Fernando. I mean, I think you've pointed there, you mentioned the GDPR, the General Data Protection Regulation, and under that, we as citizens do have the right to know when a decision that substantially affects our lives is made via an algorithm or via machine learning or via AI. That's the law. Diana, it's maybe not happening in practice. Do you think, in principle, whether predictive policing tools could ever be fair, because of course there is racism amongst people. Are we putting the blame on the machine more than we need to be, or is there some sort of way which you think it might be able to work?
It could work if the person who's putting in the data is free from all those things and puts the real information in it. And I see it doesn't happen, because when I read my own reports, I don't recognize myself. I see it also with other mothers when I read their reports. Somebody put in that the mother is slightly retarded. The mother didn't know what was happening to her. And I asked her, did you ever took a test? And she said, no, they asked her question. I said, what kind of questions? And she told me the question. So I asked her, when you answer, in which language do you think? She said, Arabic. I said, that's the problem. Because they ask you a question that doesn't relate to your culture, to your background, nothing. So when you give answers to a Western question, it will come out differently. And so you're not retarded. But that's what they wrote down. So even the questioning is not fair, because everything is based on Western ideas, but we forget the culture, the cultural insensitivity that's still in those people, and the people who are providing those data. And I say a computer is not right, because I learned in school in my early days that the teacher always told me, I never forget it, the computer is always right. It's on you. You have to it's what you put in that will come out. And what's coming out now, it's not okay. So we're still having problems, because the data is not real, it's not honest, and we're losing. And then nobody's going, and who's going to protect us from this system? Because we're going to lose from the systems right now. And that's my experience. So we're not ready for artificial intelligence as long as the people who are providing the data are not ready also. Where are you going to find a neutral person?
Well, it's difficult enough to teach cultural sensitivity to people. I'm sure teaching it to an AI is even more challenging. Laura, let's talk about who's teaching these machines, because we talk about predictive policing, we talk about law enforcement, and the assumption may be that these algorithms, these AIs, these various models that we're talking about are created by law enforcement themselves, but that's often not the case. I'm thinking of things like Clearview AI. They're commercial products that are on the market that are pushed at police forces and said, use this, use this. So there's an incentive, I suppose, there from a financial point of view to increase their use rather than reduce their use.
Yes, absolutely. And there is a lot of pressure, and including on the EU institutions, to push forward on basis of commercial interests, on the grounds of promoting innovation, and the industry in Europe to push ahead with regulation that enables the development of these technologies. But generally, we know that these technologies are opaque. We don't know how they're developed. There's a lot of the time in countries such as in the US, you have intellectual property rights that prevent information about how they're being developed and how these algorithmic assessments, what's being taught to the machine. And it makes it all the more difficult, obviously, to see how any sort of safeguards or any right to redress could actually effectively be implemented in a way that would just deprive any form of safeguard from a meaning. And beyond that, I think that we're also creating a system, or allowing through the use of these tools some form of institutionalized racialized suspicion and trapping people into that setting without them necessarily even knowing what's happening. So there is this is the lack of information, the lack of transparency, and in particular driving forward commercial interests when we're talking about such fundamental rights and such potential for harm is just not acceptable as an argument. And there are no legal redress mechanisms that can compensate for that.
Well, Fernando, Laura's mentioned there that that obviously there's these companies, these private invested interests. Are you seeing lobbying on this in the Libe Committee? I'm sure you probably are. Are there different viewpoints, sort of maybe, as you say, defending commercial interests or so-called innovation in these areas that are pushing back against any sort of ban on facial recognition?
Well, yes, I would say yes. There's a strong lobbying on the Libby committee, and I could say that it also happens at the AI special committee. You know that the special committee was set up on AI, and there are some other files, reports, and opinions on the go with regards to artificial intelligence. And they are lobbying, of course, on the most controversial issues, and this is causing, I would say, a clear positioning of the center-right forces in the parliament along some conservative views on as regards to artificial intelligence that we don't share. And I would say, I'm happy to say that most groups, most progressive groups in the parliament can't share. At this moment, the most controversial issues are the continuous attempt by the right-wing groups to undermine the GDPR. They see it as a narrow limit, and we believe that it's a reference we have to bind to and reinforce. And surely that's a legal frame that would need some reforms. But at the moment, it's a reference we have to bind to and reinforce. They have very little concern as regards to the consequences of the use of artificial intelligence on the realm of law enforcement. The ban on face recognition is also key to this, and there's no agreement on that, of course. And I would say that they also show a very bold market-focused approach. When I say they, I mean that the right-wing forces in the parliament, very influenced by the lobby group, but the lobby work that's being done here in different committees and work places on AI. As I was saying, a market-focused approach that stands for a very low level of control of the private sector, and subsequently, there's a clear gap between progressive forces and the center-right's approach as regards to the needed public and a strong regulation of artificial intelligence. Center-right forces defend a very, very up-to-market approach and do not care too much about issues like civil liberties and no discrimination that are crucial for us. As I said before, I have to add that as of today, we are quite happy that we are being able to share a common ground of approach along the Greens and S&D parliamentarian groups. It's a bit early to talk on the outcome of the works open here in the parliament, but I'm confident enough that this collaboration mentioned between progressive forces will create some opportunity windows for a more reasonable and a more respectable outcome of overall liberties at the end of the works.
Well, Diana, let me turn to you. We're talking a little bit about the lobbying on this AI law that might, we don't know yet, ban facial recognition from law enforcement use. Let me play devil's advocate. Do you have any sympathy for the law enforcement agents who might say, but this is a tool. We're dealing with terrible crimes. We're here to sort of police people who are doing wrong. Give us the tools we need to do that.
But that's not the tool they need.
Okay.
I'm very... The problem is they see these families, let's say something went wrong, the boy's damaged. We're like collateral damage. We're like guinea pigs for the system, but just destroying families on the way. So you need the use of artificial intelligence. I don't mind if you use it to find a car, a missing person, but if you want to use facial recognition, let's say about cosmetic surgery, things like that. How do you got to implant that? Use common sense, use your intuition. If you can even see the difference between us in real life, how do you gonna let a system see the difference between us through a system? Because they say all blacks look like each other, all Moroccan people look like each other. How are you gonna beat that? Are we just collateral damage? I don't think so. I
Well,
won't
I think
allow it. I'm sorry. You have to deal with me now.
well, that's a formidable challenge, Diana. Thank you. And I think you've pointed to something that we do know, that in testing, a lot of these systems struggle to identify black faces. They even struggle to identify women's black faces even more. In so-called blind testing, they fail badly on this area. Laura, to move it on from simply facial recognition, that's not the only tool we're talking about here. Is it in some senses the low-hanging fruit? There are other biometrics, there are other problems we see with algorithmic policing. Could you identify some of those areas as well for me? I know you mentioned some at the beginning, but in a little bit more targeted way in what the AI Act might be able to do.
Yeah, so our focus is very much on these predictive type of systems. So the profiling, the prediction of future criminality. And we've seen this used in policing in different countries. So in the Netherlands, there are a few systems such as the Top 600 system, the Top 400, and a Pro-Kid system, which targeted children under the age of 16. We also see the use of predictive policing systems in the UK and also in Germany. So these are all documented in our reports. And beyond that, we've also documented some of these systems for to determine criminal justice outcomes in terms of prosecutorial decisions. So for instance, this has been tried in the UK, and also in determining sentencing and probation. So here, this is the case again in the UK and in Spain, as I mentioned. So, our work and our advocacy is very much targeted on these types of predictive systems. That at the moment are not adequately addressed in the current version of the AI Act. And that's why we see very clear areas where amendments are necessary in terms of an outright ban for these types of predictive systems. And then, as I'd mentioned, in terms of much more robust transparency requirements, and also in terms of a redress mechanism.
Thank you, Laura. I think I have a couple of questions that have come in from our audience, and I do encourage everyone who's watching online to put your questions and your comments in the chat. One, I think, is possibly related to this question of redress, asking how do you envisage dealing with deep fakes that lead to the erosion of a person's integrity and innocence, and societally does this place human rights at risk? I think we're talking here about harms and damage done by malicious actors using AI, which is a slightly different question, but I don't know whether, Fernando, you want to address whether or not that's within the scope of the AI Act.
Well, I do believe that the AI Act should be changed. I think that the concern we have to talk most about is discrimination and how it perpetuates all sorts of bias, including ethnic and racial bias, but other forms too, and how it is practically not possible to guarantee that data sets are free from bias, or how it cannot be removed in a generalized way. And we have to keep in mind the issue of facial recognition and how it has to be banned from public space. The face is really the only part of our body that we cannot simply cover. So facial recognition is the most intrusive scanning you can do in public. The Artificial Intelligence Act has this structure based on the risk levels, and maybe that makes sense for a certain number of applications. There's a risk that it will fall short. Again, we think that facial recognition that can be used for mass surveillance is not just a high risk, but has to be banned. Every artificial intelligence that makes predictions based on human features or behavioral data can be abused. There should not be. There should be no illusion. The Artificial Intelligence Act mainly regulates the placing on the market or using of artificial intelligence technology products. We should add that it also grants specific rights and remedies to the people who are subjected to artificial intelligence, in particular when they have no choice. It's not enough to say that GDPR regulates this already, or to leave that to other specific legislation. We also want to see some rules on the development of artificial intelligence and the companies that develop the products. There should be no development of products where the use in the European Union would be illegal. In the same vein, we are very skeptical of the model of legislative sandboxes. And on governance and supervision, we are in favor of an European Union system of enforcement. But we have to make sure that the right lessons from GDPR enforcement are learned, so that there is really able action on European level that cannot be blocked by one supervisory authority. And that all supervisors have sufficient staff and resources, of course. I would say that full transparency of algorithms also to enable public research and scrutiny. That's a basic issue. Thanks so much.
Well, thank you. I mean, transparency is clearly one of the ways in which we can shine a light on what's happening. Diana, what would you like to see in terms of redress? I mean, I'm thinking along the lines of things like, minimum data retention periods, whereby the information in your son has to be deleted, even if they have collected it in the first place, or methods to try and give you more insight into what's going on. Is there anything that you feel might be useful as a tool for mothers like yourself to push back against the system?
Now, first we want all our information about our sons. And after the period, we want to delete it. It never gets deleted. It's always on paper. Because I went in an encounter, a small encounter, and they all brought up all my information again. I was like, that, how did you get that? And why it's still in the system? And they use the data to also target the future boys, and I don't want that, and it hurts because it's not the real information. So I want their data to be erased, but it's impossible. They say it's not. They say nothing. They say it's all secretive and everything. And I want transparency. How did my son get on the list? I know now how he got on the list. But I want this information also be available for every mother and every, let's say, father, parents, the caretakers, to have access to this information. Because if we ask for the report, they say, oh, it's too much work, or oh no, we have to wait. Because they're keeping our data to use it for future boys and girls also. So I want all the information. I want it. We must access it. We don't get access to our own information.
Laura, we're talking there about access to information, transparency, what could be maybe done in the AI Act. But as Fernando also mentioned, there are other tools. We already have rules around data retention. We already have the GDPR. We are looking at questions of new laws around e-evidence and so on. Do you think the AI Act is going to be the right instrument to deal with all these problems? Do we need more horizontal thinking? What's your view on what really can be done at EU level, especially when you consider that some issue of defence, policing, national security is an actual member state competency? It's down to the national governments rather than something to be dictated from Brussels.
Thank you, Jennifer. Yes, I think that there's a lot more that the AI Act could and should do, because there are some mechanisms, as you pointed out, with the GDPR, for instance. But here, when these sorts of criminal justice decisions and outcomes coming out of AI systems or automated decision-making systems of profiling emerge, they have immediate impact. A person will be arrested, might be deprived of their liberty, might face pretrial detention. So we need to have clear routes for challenge and an immediate challenge to stop immediately any restriction, unlawful restriction to liberty, to the right to liberty, so that the person can be released, for instance, when the person has been misidentified, for instance, or is simply caught up because of various past police reports, and pretrial detention, for instance, imprisonment is not justified strictly on the grounds of the of national legislation. And so we need in the EU Act to have clear routes for challenge and redress for individuals who are attempting to contest or challenge the decisions that stem from these types of systems. And that will go through disclosure, because as long as you don't have information about the basis and the grounds for your arrest or your detention, you won't be able to challenge those grounds. And so I would add, as Diana said, we need information, we need access to information, but we also need to be able to challenge that information and have it removed as quickly as possible, because this has very severe consequences and immediate consequences on people's right to liberty.
Thank you very much, Laura. We're sort of talking around the same subject over and over again, I know, because it's very frustrating trying to get to the bottom of this. But I have a question in, Fernando, for you, specifically from Johannes Alfeld, saying, aside from the big multinationals, who is lobbying the EP most intensively? Is it law enforcement organizations or private security companies? I know you've touched on this already, but if you could answer that for Johannes, please.
Well, I cannot offer very particular answers on the side that we, as a group of the left, I have to say that we do not get too much lobbying. I think that lobbying as regards to the multinational enterprises and private sectors. I think that they know that. We have quite bold positions on some key points that make not so much room for lobbying, and therefore it's quite a low level lobbying, the one we can receive. But it's but as I said before, it's quite clear that this lobbying is happening, particularly as regards to the center-right groups that bring sometimes quite similar positions to the committees and working groups as regards to central points I mentioned before. Some of them could be more political or more political culture focused, like the issue of law enforcement and some others. But it's quite clear that they are getting that lobbying pressure on the side of the market approach of the artificial intelligence regulations and work being done here in the Parliament. That's quite clear in the case of some center-right. Groups that are much more concerned in defending that I would say corporate approach of the future development of artificial intelligence, that in some other realms that are really crucial for us as well, I would say, over the influence and consequences of AI to overall liberties. That's the situation now, and it's quite good to be on the side of left politics here, at least in the European Parliament, because, as I said before, the lobbying from corporate interests we receive is a clear low, very low one.
I think it's you've made your position clear, so perhaps you're a lost cause to those who are lobbying the opposite. A final wrap up. We're right at the end of the time for this panel, and I know it has been far too short. But Diana, what's your final takeaway? I mean, this is about structures of power, and those who have it will continue to use it. So, in a quick one phrase or one sentence, what's your call to the policymakers?
Whew, I don't know. I just don't use it yet. It's too tricky. You're gonna hurt a lot of people with it, and a
Thank
lot of
you.
families will be destroyed.
Yeah. Laura, aside from listen to people like Diana, what's your call to the policymakers?
Well, definitely listen to Diana and to the harm that this is causing. It's just, as Diana said, it's too dangerous to be trapping people into a criminal surveillance net that is created by technology. And even you mentioned the structures of power, and even if policymakers might not be representative of the communities that are trapped and targeted, they need to feel concerned because the harm that this is causing to people is not consistent with what we want for Europe, for an inclusive and diverse Europe. So we really need to take strong action on with the EU AI Act and ban these types of inherently dangerous procedure systems that can't be remedied through safeguards, for instance.
Thank you. And Fernando, I'm just going to ask you in a quick word, are you optimistic about the outcomes of how the AI Act will look in the end?
Well, I would say yes. I cannot assure what the final outcome will be, but as I said before, there's quite a good atmosphere in regards to the progressive groups of the parliament that could bring some good opportunities as regards to that outcome. I believe that the concern we have to talk most about is discrimination. How a wrong use of artificial intelligence perpetuates all sort of bias, and beyond ideological or political stances. I think that is the point we have to preserve the most, and that is the point that we are trying to work about in the artificial intelligence and related committees and special work groups here in the Parliament.
Well, thank you very much. And to all three of you, do keep up the great work, keep up the good work, and let's hope that the end result is something approaching what we would like to see. So thank you very much to all our panelists for this, our first panel today. Do stay with us. We have a lot more discussions to come. Our next panel also deals with the question of an imbalance of power, not that between law enforcement and the average citizen, but between the workers and the bosses, and the systemic algorithmic surveillance of workers in the platform economy, specifically within the platform economy, because we know that those workers are often the ones with the fewest rights or the fewest forms of redress. We're calling this Watching the Working Class, Surveillance and Algorithmic Management of Workers in the Platform Economy. And we have another three great speakers for you here. We have Yassine Aslam, is the co-founder and president of the UK-based union, ADCU, which is the App Drivers and Couriers Union. Formerly an Uber driver himself, Yassine reached global recognition as the lead claimant in the court case that brought Uber to classify its drivers as workers, something we know that they'd been trying to steadfastly avoid doing for quite a long time. Amasto is a senior researcher on artificial intelligence and human rights at Human Rights Watch, a well-known organisation. He's joining from the East Coast. So thank you very much for getting up and joining us. And I know this is an awkward time for you, but we here in Brussels are very keen to hear your views. And Kim van Sparentak is a member of the European Parliament and obviously heavily involved with the Greens group. She's the shadow rapporteur on the AI Act in the IMCO committee, that's the Internal Market Committee in the European Parliament. So all over these things from a political point of view. Yassine, let's start with you. You've got a real world story, very much like Diana. In our last panel, you've come up against the hard face of this problem yourself. So tell me a bit about that. Tell me what your case was about and how its outcome has been received.
Yeah, hi, Jennifer. Nice to meet you, and thank you for having me here today. So my background is from a worker. So I actually started working for Uber in 2013 when they first sort of launched in London. And I was one of the first, the lead claimant, the case against Uber, which we fought all the way at the Supreme Court. So this was for basic employment rights. So back in 2015, we filed in the tribunal asking to have basic right, and Uber fought us all the way in order to deny us our rights. So last year at the Supreme Court, they clarified our position that we are workers. So what that means is Uber drivers in the UK are now entitled to basic rights such as the right to earn the minimum wage, the right to earn the holiday pay, the right not to be discriminated against. So it's just basic rights. So don't forget, in the UK we have three status. So we have like a self-employment where you're completely self-employed. You also have an employee status, which is right at the bottom, meaning you have so many rights as an employee, such as maternity, paternity, the right not to be unfairly dismissed, where the status we want is just a middle status, meaning we just get basic right. And that's about it. So this was a case that we started a long time ago, but the way things are going today, especially as we're seeing more and more platform work, it's very important for us to actually have these employees right. That's what we really need. But cut long story short, even though it is a long fight, it was a fight that we had to, like go through many challenges, struggles. Grateful for all the support from the lawyers and the people around us in order to win this. But Uber is still failing to comply with this ruling. So in our case, where the Supreme Court ruled that we were workers from the time we log on to the to the time we log off, and how Uber interprets it is that we are only workers when we have a passenger in the car. So the fight still continues. So, as we move into this space, we're seeing more and more issues such as, AI, the way the work is dispatched around algorithm management and all these kind of issues. So these are some of the stuff, like that is ongoing. But just to give you a little background, like the drivers we represent, or the drivers in the UK, 94% of them are from Black, Asian, ethnic minority community, and 71% of them are from deprived communities. So they actually rely, like models like Uber, they actually rely on BME workers that they could exploit that come from these migrant backgrounds. Yeah. So just a quick insight. But like I said, I mean, we started a case, we won it, but the problem we have here is we have a big, massive, giant company that's actually literally could afford not to obey the law, and that's the situation we have.
Yeah, I think we sometimes see these companies, as you say, it's a cost of doing business, these court cases against them. So that's incredibly problematic if even the law is falling short in defending rights. Amos, Human Rights Watch watches this. Tell me about the impact of AI systems, and also in relation to workers, but also those on social welfare, because it is not just those who are working for these big companies, it's broader than that.
Yeah, thank you so much for that, Jennifer. As Yassine said, companies like Uber and other digital labor platforms are, really relying on the work of many precarious workers to actually function as a business. And a lot of the time, precarious workers for these platforms are actually being managed and controlled and paid and hired by AI systems, right? To give two examples, we have found, for example, in the US, and Workers Info Exchange has also found in parts of Europe that some digital labor platforms are using black box algorithms to generate earnings. There are also other types of AI systems, such as online rating systems, that are meant to kind of rate the performance of workers, that also can be profoundly unfair and has a huge impact on what workers can see on the platform in order to do their jobs or even their earnings. And workers have little effective means of challenging these rating systems. So we are actually seeing that there is, a real presence of artificial intelligence on platforms that are affecting workers' rights. At the same time, people who show the burdens of precarious work are also more likely to interact with social protection programs. So in the UK, when we were researching our reporting on universal credit, which is the automated benefit system in the country, one of my primary sources of interviews was the Independent Workers Union of Great Britain, which is the leading union for platform workers and other precarious workers. And what benefits volunteers told me was that a lot of platform workers were experiencing issues applying for universal credit during the early stages of the COVID-19 pandemic, in part because of the way in which the system was digitized and automated and did not actually take into account the fact, that people were unbanked or that people did not have the kinds of digital literacy or tools that were required to apply for the benefit.
Well, thank you. You're mentioning a lot of these areas, and of course, they're not just used by the platform working community as well. We see issues with companies like Amazon monitoring their workers in a way that's deemed to be a little bit too invasive. We see lots of court cases around that. I'm sure we can speak about that in due course. Kim, tell us again from the Parliament's perspective. We're focusing on the AI Act today. But feel free to broaden that out and tell us what's being done with regard to workers' rights in the digital area, if you like, as well.
Yeah, thank you very much for that question. So for a long time, we thought digitalization would replace our jobs, right? And what I find extremely worrying is that instead, in name of efficiency and productivity, technology is deployed on the workplace to turn people into living robots. And this parliamentary term, we are really making some fundamental choices about the future of work in a digitalized world. And to me, there are two aspects to tackle. On the one hand, there is the aspect of surveillance at work. And on the other hand, there's the aspect of opaque, dehumanized algorithmic management that Aslam told us about, making decisions with huge impact on people's lives and rights. And surveillance is about constant monitoring of time spent on a task, location tracking, and even tracking of keystrokes or where your gaze is fixed. And for example, also companies deploying emotion recognition on the work floor to evaluate workers' performance. We've heard of the real-time progress monitoring in Amazon warehouses, but also monitoring, time on breaks, including bathroom breaks, but also emotional recognition software that's deployed in call centers to monitor performance and to hear whether, they're sounding chirpy enough towards the clients. And then we have the algorithmic management, which is more about task assignment and evaluation of workers, which is also increasingly deployed, not only in platform work, but also in the warehouses. So, for example, the evaluation of workers based on the data from constant monitoring, or also monitoring and punishing behavior, where online platforms such as Uber track workers' behavior, such as logging off, all without telling the workers. And in the end, this has then an influence on, for example, their pay or whether they get, certain rights that are better for them. And what we see is that the AI Act does not tackle any of this at the moment. And the current AI proposal is strongly based on a product safety approach, whereby any AI is, has its bias eliminated and complies technical specificities is deemed safe. But even if AI works perfectly with no or little bias, it can still be used in violation of fundamental rights and, harm social rights or workers' health and safety. So the AI Act has no real rights for workers when AI is deployed at the workplace. I am happy to see that the Commission has taken it on board in the EP's call to regulate algorithmic management in the Platform Work Directive. And I really think this is a huge step, although the text can still, of course, be further improved. But to me, constant surveillance at work should be banned for all workers, and all workers should be protected in case of deployment of AI at work. And I think what is most important is that we really make sure that the legal protection of workers against the deployment of technology and AI at work, including algorithmic management or monitoring software, is currently completely fragmented and still leaves huge gaps. And we have the GDPR, we have the AI Act, we have transparent and predictable working conditions, the Platform Work Directive, and EU rules on occupational safety and health. I think we're doing something completely wrong if workers need to hire an army of lawyers just to understand what their rights are in the first place. So what I would say is we need an EU framework to protect workers' rights and health and safety when technology is deployed on the work floor. Because a work relationship is a very specific one with a relation of power, and it's difficult to rely on existing structures in digital legislation as consent. You can't really speak of freely given and informed consent if your employer installs a new system on your work computers and you can either use it or leave. So we need consultation rights, just as with other impactful changes in work relationship. And it should not be possible for employers to compromise on what constitutes paid working time through constant monitoring. Workers cannot have impactful decisions made about them or their work without getting any information or explanation. And we need specific legislation for at work for all workers. And that's why I call for a legislative proposal on AI at work. And as I said, this parliamentary term, we are making fundamental choices and we have no time to evaluate until the next revisions. We have to get it right from the start.
Yassine, Kim there mentioned the army of lawyers that may be necessary. That, in your experience, that's not the way you should have to go about getting your rights, I presume. I mean, the law is there, but if you don't have effective redress, if you have to fight all these battles, if it takes up half of your life, if it takes months and years sometimes to get that sort of redress, that the rectification, how optimistic are you that laws are going to be able to protect people who are in these vulnerable positions?
Yeah, thank you. I'm glad you asked me that because I think a lot of people forget this. These are vulnerable workers, people that don't have resources. What they want to do is just go out there, earn a living. So when we hear this word like gig economy, platform workers, people don't understand that. So it's like me when I started this job back in 2006, well before Uber come, and then Uber came in the industry in 2012 and 13. It was a job to me. It wasn't that it was something casual or whatever. And one of the things that attracted me to Uber and a lot of drivers was the fact that, we're going to be our own boss. We won't have a human controlling us. But it's just like over time, we started seeing the different side of it where we were now being controlled by a technology, the algorithm. Yeah. And it destroys your life because when you're dealing with a human, it's a lot more easier, especially when there's human errors and mistakes. You can adjust stuff and make things right a lot more quicker. But when you're talking to a robot and the computer says, it is what it is, you're technically destroying someone's life. Now, as ADCU, Advertising Couriers Union, we've been organizing in this space since 2015, and we're one of the biggest union that actually just represent couriers and private hire. So we actually got a live case going on at the moment based on discrimination, where we had one courier driver who's working doing food delivery, and we also got one Uber driver that got deactivated from Uber's platform based on failure on the facial recognition side. So we have now filed a case based on discrimination. But people don't see the impact it has on these workers' life because they're already struggling to make an income to provide for their family. And when they're suddenly out of work, especially when we talk about the Uber drivers, because they have, like expenses such as, high vehicle insurance, etc., and all that. So when they're suddenly out of work, like, it really destroys them financially as well as mentally. And on top, especially in the UK, we also have a regulator like Transport for London, TfL. So they license Uber and they also license the drivers. So let's say, like, for example, one of our members, that the case that we have filed for facial recognition, Uber reported him to Transport for London saying that this was not him. He's actually sharing it up when it was him. And the problem we had was the system was failing to recognize him because of his skin color. But he got dismissed from Uber platform, and he also then got reported to the regulator, who then revoked his license. And then as a union, we had to go forward, and we were able to get his license back. But we still have a case going on for the discrimination side. But the point is, the mental impact it has, people don't see that. Now, let's just go back onto the worker status. And that's where my expertise comes from, because I was just fighting in terms of the workers' right. The laws exist and they've been around for years. It wasn't something new. But what will happen was we had a company that had the resources to drag it out for 6 years, and it is unfortunate where the workers themselves had to, carry that burden and fight it all the way. Now, the problem we have is there's lack of education around. Like, it's like someone like myself, I don't know what the laws are, and you can't expect me to know the laws. What I want to do is go out there, do a job, and I expect the law to protect me, and that's what's not happening. I mean, in our case, like I mentioned earlier on, we have one at the Supreme Court, but what we find is there's lack of enforcement. And sometimes, like especially here in the UK, they talk about bringing in these new laws and stuff, protection for the workers, etc. But first, we've got to look at is, if we have existing laws, why are they not being enforced? Why is the burden shift onto the workers so they have to go all the way through and fight it? And while the regulators and politicians sit in the background. Now, I like EU because they are doing a lot of stuff, because I looked at the new stuff, the new proposals coming forward, and it actually fixes a lot of problem for the workers, meaning the hurdle is no longer there. It makes a lot easier. But my main concern is, okay, let's say these laws do come into place. What's stopping a company like Uber that got so much money to burn, from not obeying them? What are the enforcement actions? Would someone like the Uber executive, would they be locked up in prison? Because maybe that would stop them from making sure that they don't abuse the law and they actually obey the law. So these are the bigger, sorry, these are the kind of bigger concerns that I have from the worker stuff. Because one, you got to understand, as we move, we talk about technologies, algorithm, how the work is managed or dispatched and all that kind of. An average worker would never understand that. He doesn't know what his rights are. And one of the things we as a union did last year is we filed a case in Amsterdam in Holland for six of our members, based on the way the work was being dispatched, the surveillance that was happening. And we actually won, where Uber was then forced to reinstate these drivers and pay compensation. But my point is, an average worker that is just here in this country or just trying to make a living, they just don't have time to educate them, understand them. Now, we've been lucky at ADCU because we work in line with Workers' Info Exchange, which is an NGO run by James Farrow, who's also the General Secretary for ADCU. So he done a lot of work in terms of educating us as the workers on what our rights are, what the GDPR, like the Data Protection Act is, and how we could what we want to know is what the profiling that are being used, how the work is being dispatched, who gets to work, how they get to work, and most importantly, like the transparency and the right to object. And one of the things as a union, what we're trying to do is build this data trust, so we get access to this data, so we could establish whether there's breach of employment laws and stuff like that. But going back to your main concern, the question you asked was, yes, the laws are there or will be made, but the question, and not many people talk about, is it needs to be very clear is how it's going to be enforced. If this is going to be the law, what is the enforcement? What is the punishment for someone like Uber if they don't obey that law?
I think you're right there. I think we mentioned cost of doing business, and the GDPR, which I have heard described by business as goddamn privacy rules, are there just as an inconvenience rather than something to protect rights. But let me play devil's advocate just for a moment. Amos, what do you say to these companies that said, we're offering flexibility, we're allowing these workers to set their own hours, they've got all the tools at their disposal, and, if we're doing behavioural scoring, if they're great workers, what have they got to fear?
Well, I think that the idea that workers enjoy flexible schedules and can work whenever they want is very much a mythical narrative, right? That is undermined on the ground by the fact that workers are essentially working for an algorithm that is not only just keeping track of their every move, but also pushing out a series of behavioral nudges in order to nudge the worker and persuade the worker to work at particular times, and to work in particular areas. And so I do think that if we look at the way in which AI is structured in these workplaces, it's very much to the benefit of these platforms and not the workers or their schedules or their needs. And so I think it's really important to reframe the debate, right? And I think, to Yassine's point, I think by the time you get to expensive court appeals and expensive lawyers, a lot of the damage, I agree, has already been done, which is why it's so important to get the EU AI Act and the Platform Work Directive right. I think, first of all, we need to talk about mandated transparency that is meaningful, right? A lot of this fight for workers' rights is going to happen on the streets. It's going to happen through collective worker action. And in order for workers to mobilize around their rights, they need to know what's going on, how exactly these algorithms are determining how much they earn. To actually not know going into a particular day how much you're going to earn that day and how your pay is being calculated because it's hidden behind a black box algorithm is, the very opposite of flexibility, and is actually, so opaque in a way that it really just strips workers of their agency and autonomy. So I think mandated transparency is really important. I think, one of the proposals in the Platform Work Directive that is promising is this idea of a deactivation center. So essentially a center where workers can get to appeal being kind of booted off the platform. And I think it's important that deactivation centers like this are not just run efficiently, but also have a strong kind of workers presence, has a strong presence of workers advocates that can guide, workers who have been deactivated through an essentially very traumatizing process, right? And that can provide the support that they need. And we need to think about extending these kinds of remedial mechanisms, right, that are more easily accessible and available to workers than a court, for example, for all the other forms of algorithmic decision-making that digital labor platforms make, right? And finally, I think we can't get around the question of what AI systems in the workplace need to just be banned outright. So, in the EU AI Act, one of the proposed bans is on social scoring systems, right? And the ban on social scoring is so vaguely formulated at this point that it's unclear what it even covers. And what, I certainly hope to see is that at the minimum, it will actually ban online rating systems that have kind of an unfavorable and detrimental impact on workers' rights. And I think there is a lot of work that can be done to prevent these abusive systems from even coming on the market. Because as Yassine said, by the time you want to challenge it, like a lot of the damage has been done.
Well, Kim, I see you nodding again vigorously there. And of course, I should say I am playing devil's advocate. I'm not suggesting that we actually think these algorithms are a force for good in the way they're currently being used. But Kim, do you see sort of wiggle room in the AI Act in terms of how it might be interpreted and enforced? I mean, we don't have a final text yet, but in what direction do you see it going?
Well, I think when we're looking at the AI Act, if you see what they're doing there, it's that it makes AI in the employment sector or public sector high risk. And still the only thing this high risk classification means is that it has to meet certain technical standards. And then it gives you a green card to use it. But, even if AI works perfectly, it can still be used in violation of social rights and workers' health and safety. Think of this constant surveillance at work, to check everything, every little detail that every worker is doing. But also more broadly, I mean, we have seen plenty of examples of being flagged in fraud risk systems without you knowing, life-destroying consequences, unfortunately. And we've unfortunately seen multiple times in the Netherlands where we have a very high rate of digitization. For example, we had the Syria system or the Dutch childcare benefit scandal, which forced the Dutch government even to resign. And I think, Amos and Human Rights Watch have written about, and broader social welfare systems he also mentioned. And the AI Act does not give people subject to algorithmic decision-making any rights. And I think this is really the missed opportunity and something I will really fight for in negotiations. And unlike the AI Act, what I think the Platform Work Directive gets right is that all workers should at all time know that an algorithm is used in the first place and how it works, which factors are used to influence the algorithm, how does workers' behavior impact the algorithm, and ultimately a human must always be able to explain what is happening to the workers and why. And I think, as also was mentioned by the other speakers, transparency, explanation, and clarity on data use, people need to know what is going on and speak to another person about it. And this information should be accessible. And I really think we should get the information by default and not bear the burden of going through all sorts of processes to know what is going on. But as the name suggests, the Platform Work Directive only applies to platform workers. And I really think all workers should get strong rights when AI systems at work at you. And of course, we also need strong enforcement because tech companies that currently use the system most, such as Amazon and Uber, also other tech companies, think of Amazon and Microsoft, are all renowned for trying to circumvent the law. So I really think that what is most important is that we get an AI Act that gives people the opportunity to, go against decisions that were taken for them, which already would lay a groundwork for workers' rights. Then we should have the Platform Work Directive that sets strong standards for the platform work economy. And on top of that, we need AI legislation for specifically on the work floor. And I think, we really have to create a movement that works together. Social movements, trade unions, but also tech companies that work together, create a safe environment, and make sure that that artificial intelligence, if deployed, is deployed in a way that doesn't harm but actually brings good.
Thank you, Kim. I'm going to ask Yassine for you to build on that idea that Kim has mentioned there, that it's not, I know your union is specifically about drivers and couriers, but do you see areas in other forms of work beyond those two specific areas where the experience you've had could be brought to bear to their advantage as well?
Yeah, I mean, I think, like I said, app drivers and couriers union, we're focused on the drivers and the couriers, but don't forget the fight actually extends to every single workers. We're not just saying it should be. I mean, it's just like if you look at the example of the Uber case, it benefited over 1 million workers here in the UK. So even though there's 100,000 Uber drivers, so when we go through these procedures, when we're fighting these transparencies, the IA Act, it benefits all the workers. There should be, and when you look at it, unfortunately, it's always the people that are at the bottom that are highly surveillance and classified as criminals, where the high elite people get away with it. And it's really like like the balance needs to be, there is a big massive imbalance, and it doesn't matter whether you're Uber driver, or you're a courier, or you work in some other sector. The protection should be the same for everyone. So it shouldn't be just like I said, I mean, I'm only focused on what we do for our members, but it goes beyond that. And the same if you look at the case we did in Amsterdam last year, which was about the transparency and the Article 22. They were test cases, and it opens the door for other workers and other sectors as well. So it's quite important going that. But I just want to address one issue that you mentioned about flexibility, because I hear that a lot, especially when you speak to companies like Uber. They say, look, one of the best thing about our model is the flexibility. And I think we need to get rid of that, because it's not flexibility. I mean, in London alone, we had drivers working 70 hours, in a week. They're making below minimum wage. And what these people need, especially when you're right at the bottom of the chain, you need that protection. We need these rights. We need the law to protect us. And like if we have to be employees, that is the way it shouldn't be. A worker shouldn't be choosing between his flexibility and his statutory rights. And that's the way it's been spun around a lot. And secondly, I do like what Kim and Leila in the Europe are doing, because it's helping workers. Like there's a bit of everything, as Ahmed said. Like, look, you need to get the workers organized. They need to own these movements, and this is where trade union comes in, because it gives workers that power to fight, campaign. You need to be doing protests, you need to be doing strike action, but a lot of it is also lobbying. Now, Uber, like companies, and sorry for this, I keep saying Uber because when I refer to Uber, I don't just mean Uber, but these companies have money for lobbying, and they could go out there lobbying where workers like myself don't have it. And we need people like Kim, we need supporters within these parliamentary kind of stuff who will fight for workers, yeah, because we don't have that power, the lobbying power, and a lot of stuff is done through these channels as well, because a lot of stuff, like you have legal action, you have direct action. We also need the government sort of taking that role as well, protecting the workers. So, like the EU is doing the right thing there. But at the same time, what I'm seeing now is as we started winning, so it's like the workers' status case in the UK. It wasn't Uber did it by choice; they were forced to do it, and it's the same with the EU. I know there are some good laws coming forward, and I'm very confident and hopeful that they will pass through, and eventually it will fix a lot of problem. But the question here is, Uber would now go out there and try and buy out unions and try and get these dialogue going. But what that does is it slows the process down. So it's like, if you look at New York, they have a union there called IDG. Like in the UK, they have done a deal with GMB union. They also recently announced they recognize ITF, International Transport Federation. But the question is, how many workers are actually involved with these unions on the table negotiating? And that's where, when we talk about that imbalance, the imbalance is still there, because it's not the workers having that, dialogue. They're not involved in the process, and that's quite important, because what I believe Uber is now trying to do is they know they lost, they know the workers are organizing, and they're looking at ways of how they could undermine these workers. And when they do these deals with unions, it undermines the workers, because the workers have no say. So it's like in the UK, where we want the full working time. I don't need to sit on the table with Uber and negotiate what my working time is, because the court have already won it. And it's the same like the EU stuff. We're going to see a lot of these lobbying, a lot of unions being brought out by Uber. And that is my bigger fear, because it's their way of trying to undermine, all these AI Act and these directives that are coming forward.
Well, undermining unions is, of course, something we've seen as a standard playbook in order to disenfranchise workers, that perhaps we see in certain countries more than others. Amos, I'm interested in your perspective as to whether something like Yassine is suggesting, that an EU law might be exportable and raise the standards around the world. Is that likely when we talk about platform workers, or are these companies almost too big to regulate?
I do think that the EU's legislative efforts in this space will have global impact, right? And I think we already see that in very small ways with Uber. If you look at some of the things that they have been compelled to disclose because of Yassine and other workers who have fought hard in courts to get those disclosures under the GDPR, you see that those disclosures actually do help worker movement in other countries as well, right? So it's important to kind of also think through the global implications of essentially regulating global platforms, or platforms that have ambitions to be global. Right. So, things like transparency and accountability, and things like implementing a deactivation center and algorithmic transparency are all really standards that will go a long way in improving kind of global conditions. But I also think that it's important to ensure that we kind of empower local movements, right? To make sure that, you know, it's precisely because of local movements that we actually understand what the concerns of workers are in particular areas, and how they experience platform work. So I think it's also really important to have legislation that is tailored to local needs.
I think it's interesting as well to look at what these laws are used for. For example, just this week, Amazon workers in Germany, the UK, Italy, Slovakia, Poland, and a few other places are actually using the GDPR law to try and get data transparency about how their movements are being working, as they've been trying to use employment law and employment rights, but they've actually seen that the GDPR might be a better avenue for them to pursue. Kim, that's a lot of responsibility on you as a lawmaker and a policy maker. To what extent do you feel the voices of workers and unions are heard? Because we are talking about, we talked in our last panel about lobbying from law enforcement, lobbying from these big private security companies. Do you see the same thing happening in the area of platform workers and workers' rights, that it's the companies with more clout in Brussels rather than the unions?
Well, definitely. Like the amount of lobby we are receiving from these big platforms, specifically Uber and the other ride-hailing companies, but also from the delivery companies, they are present and they are not very friendly, just to say it like that. But what I think is really amazing is that you know, they are just a part of the story, and they are not winning at the moment. If you look at the proposal, if you look at the Platform Work Directive, I guess they're not very friendly because the Commission chose the side of the workers. And it was the promise of the Commission. The Commission said we are going to tackle bogus self-employment, and we're going to make sure that people who work for these platform companies are protected by the laws that we have. No company is too innovative, or whatever kind of story they will tell you, to actually make sure that they treat their workers properly. And they did that. The European Parliament already called for it. Make sure that you know, they have the right to be seen as a lawyer, to be as a worker, to be classified as a worker, to make sure that we have proper rules on algorithmic management. And you know, also in the proposal from the Commission, the Platform Work Directive, it's very clear we are going to tackle bogus self-employment. There is not such thing as an in-between status, but these people are workers, and we are going to make sure that their rights are heard. So it's very interesting to see that now the platforms have become even more vocal to make sure that we change our minds on that. So far, I haven't heard many of my colleagues falling for that, though.
Well, let me remind our audience, first of all, that if you have questions for any of our panelists, please do put them in the chat. We'll be happy to deal with them. But Kim, let me come back to you, because I'm quite curious to know, what are the arguments that you're hearing from these companies? I mentioned, flexible working, but are they giving you other examples that we need? I mean, in order to understand their position, if we want to combat it, we need to know what it is that they're claiming.
Well, indeed, their main argument is indeed we asked all our how do they call them now? I guess workers, not employees, of course, what they preferred, and if they preferred having a contract or flexibility, then they prefer flexibility. To which I answered, well, that's a bit of a biased question, because you can also provide flexibility and treat them right and give them the proper working conditions. And then I said, so basically, I would say your survey is biased. And then their reply was, well, every survey is biased, and even the research done by the Commission you could claim is biased. And I was like, well, that's not the strongest argument I've ever heard, but that was one of their things. The other argument they have now is that a lot of work will be lost because every job that you can accept, of course, as a gig worker, is then seen as a work opportunity. And according to them, a lot of work opportunities will be lost. So the amount of people that can then do one ride will decrease. We've asked them already multiple times because, for example, in Switzerland, they now have a new regulation. Okay, so how does it work out in Switzerland? How many work opportunities, as you like to call them, are actually lost? They have no data on that. They have, or maybe probably they do, but they don't want to share that with us. But this is the main thing. They are saying the people that we are helping with these work opportunities, they will lose these opportunities. And one of the arguments that they're using a lot, which I think frustrates me the most, is that they're saying we are helping people that have difficulty to get foot on the ground on the labor market. People of color, single moms who find it hard to find a job because they have they face bias and discrimination on the labor market. And these are people who indeed have a more vulnerable position in society. And those are the people that they say they are helping, but they do that by exploiting them and not giving them any security or safety. And I think that is the argument that just infuriates me the most, and something that we really have to push against. Of course, I won't say that there is no bias and discrimination on the labor market. That is something we have to fight against. But saying that you're helping people by giving them a job that in the end doesn't give proper protection is definitely an overrated statement.
Thank you. Yassine, I'm interested also from your perspective, what sort of egregious arguments you've heard for the use of various technologies. We often hear things like, oh, it's fraud management, or it's just measuring performance and it's therefore good for the drivers. I'd be interested to hear what sort of bad examples you've encountered.
Yeah, I mean, it's quite an interesting thing. So I just want to start off with what Kim said. I mean, it's quite important because when you look at these models like Uber, they heavily rely on, for these models to really expand, is to exploit workers. And the worker they rely on are the BME communities, yeah, like vulnerable, desperate people. And the reason why they pick them, because they don't have the resources, they won't challenge, they won't spend 6 years fighting in and out of court. So when there are laws, that's a big, massive obstacle for Uber or companies like Uber. So they want to do everything to, stop that from happening. But going back, like I started working for Uber when they first launched in London. And I see this in other countries, like I talk to drivers from different countries around the world. When they first launch in any city, they spend a lot of money. It's like myself, when I first started working for Uber, I was grossing £50 an hour, which was really good money because Uber was actually giving all these bonuses and stuff like that. And that's their way of coming into the market. They make it so good. The fares are a lot more higher. Not everyone's using it. They have less rides. But eventually, as they start going for that mass, like as they start scaling, making their fares cheaper, getting more and more workers on the platform and reducing like as they scale, as they get bigger and bigger, we start seeing the different side. And my point is, look, the model is sustainable, meaning they could operate at a high end, like if they want to protect workers and have all these protection and just, like do what they're doing, they can do it. But if they want to be greedy, and by greedy, what I mean is by exploiting the workforce and, benefiting on the back of all these hard, like migrant workers with no rights, yeah, that can't be right. So, like, and it's very important to say that none of us guys are anti-technology. We're not against technology. What we're against is all these surveillance, like the way there's no transparency, there's no protection, all that kind of stuff. So, like when we see, and when you mentioned the fraud stuff, like we get a lot of drivers that get kicked off the platform fraud. But when you look into it, what was the fraud that they done? For example, they might have cancelled a few jobs, so in order to get away from that employment liability, they'll classify it as a fraud. We get drivers, getting dismissed for, like there's all kind of reason. Maybe it's because you're like a rider made a complaint against you, but you have no right to challenge that, so you don't know what the complaint is, so you can't object to it. So we see all these kind of stuff that we ourselves don't know. So there's like a performance management, like even again, like when we get the jobs, like the fares, we don't know how those fares are calculated, what's happening when they call it the fixed fares, how the commission works. So there is no transparency. And on top, there's a high level of surveillance. Like, for example, even when I'm not logged onto the app, I am being surveillance. And what's really interesting about this is when Uber first lost their license in London, the Met Police, which is one of the biggest police force in Europe, actually come forward in Uber's defense to say, look, they need Uber to be relicensed because they need it for they get this data, surveillance data from Uber. So I am being, like all this, like my data is being shared with third party, but I don't have access to it. Now in the UK, all these drivers or couriers that work for Uber, they do this enhanced DBS check, so meaning there is no issue. But why are they being surveillance? So we got all this stuff. So it's just like like when we see this like when they had this fraud possibility scores or whatever, we just don't know. No one knows how it works. What are the profiling? Like we just don't know until they're really open and transparent. Then we know what is what. But at the moment, there is no transparency. So it's just like the workers trying to fight and trying to get that. Now, just if you look at New York City, the taxi limousine commissioner, the TLC they called, they actually put some conditions on Uber's license there. And this was based on after they received all this data, they analyzed that data. And since they put these conditions, the workers or the drivers working for Uber, their wages went up. So meaning having access to that data does, it can solve a lot of problems. So but the main problem we have as of today, no one knows what is what. So it's just a hidden side. There's a dark side to Uber, and Uber would never expose it. They're doing everything possible to fight it and keep the lid on it.
Well, Amos, I want to broaden this a little bit because Yassine mentioned that the disadvantaged drivers, I mean, they often come from disadvantaged backgrounds, or perhaps there's more systemic issues at play here. So I know you've also been researching around the area of social welfare or social benefits and the role of automated decision-making or algorithms in that. Tell us a bit more about what you've been working on and what sort of conclusions you've drawn.
Right. I do think that the future of work really depends also in large part on the future of the social safety net, right? Because as work becomes more precarious, what we are also observing in the social protection space is that a lot of social safety net programs in Europe and beyond are increasingly being decimated by, very abusive forms of automation. In the UK, for example, we, with universal credit, as I mentioned earlier on, many precarious workers pay rent through informal arrangements, and they aren't actually on the lease, right? But you can't actually convey that to an automated system when you're applying for benefits. And so because you can't explain that to an automated system, people's rental payments are therefore not legible to government systems, and that deprives them of the housing benefit component of their social protection benefit and social protection measure. So we see these kinds of things happening, and we see that automated benefit systems are very out of touch with the lived realities of precarious work and what it's like to live from paycheck to paycheck. So it's important to kind of really address that. And the other thing I would say is that, we are seeing quote unquote AI innovations in three areas of social protection. First, when it comes to verifying identity, you've heard Yassine talk about fraud management and the use of these kinds of surveillance tools in the workplace, supposedly to monitor for fraud. A similar kind of narrative is actually happening in social protection programs. But the reality is that these kinds of identity verification systems actually end up excluding people who are in fact eligible for benefits and making it a lot harder for them to apply for benefits. You also see automation being introduced to means test and evaluate people for benefits, and to also counter fraud at the back end, to investigate people for fraud and single them out for very intrusive forms of surveillance. So one of the more kind of egregious examples of algorithmic profiling that we see in the social protection space is in Austria, right? And Epicenter Works and Professor Doris Alhater an Austrian academic, have documented how the Public Employment Service, which is the unemployment agency in Austria, is using an algorithm to predict a job seeker's employment prospects based on factors such as their gender, age group, citizenship, health, occupation, and work experience, and prioritizing people for job support services only if they have moderate employment prospects. So if you have low hiring prospects or employment prospects, then you're relegated to so-called crisis support, which is very threadbare forms of support. And I mentioned this because if you are a precarious worker, if you are a precarious worker trying to transition from precarious work to something more stable in a place like Austria, this algorithm is not your friend, because it could just use your history of precarious work to say that your job chances in the future are very low, and so we shouldn't prioritize you for support. So this is profoundly unjust and traps people in this vicious cycle of precarity and in-work poverty. And I think, while a lot of the blame is at the feet of companies that are trying to exploit loopholes in labor laws, to kind of advance business interests and profits, well, a lot of the blame is also at the doorstep of governments and regulators who, have just allowed these loopholes in labor law to fester in the first place, and that have, in the pursuit kind of austerity motivated policies, use technology in a way to cover up or disguise cuts to social protection and benefits that are very regressive and end up trapping people in precarious forms of work in the first place.
Well, it's incredibly frustrating to hear you say that while we, on one hand, are incredibly concerned about overuse and misuse of our data and over-surveillance, in certain cases, if the right data was there, the situation for those workers and precarious workers and those claiming benefits would actually be improved. Kim, we're almost at the end of our time here. Any final thoughts from you on what you expect to happen in the coming weeks and months with the AI Act, and what sort of forceful optimism can you give us to keep people motivated?
Well, I think what we are seeing is that the concern is growing, and the narrative of AI being magical, being like in the Hollywood movies, and just creating real life like humans, like robots. That narrative is, I think, slowly going away, and we're realizing AI can be used for good. But we have to make sure we steer it in the right direction. I think indeed there is still a gap when we're talking about workers' rights, and the effect of AI and digitization on workers' rights, but also that is coming, more and more in the political arena. It is a fight that we still have to do. But what brings me a lot of hope is to see that, digital rights organizations, trade unions, but also like workers on the ground and people in society, they are now coming together and saying, we want to make sure that all these regulations get better. We want to make sure that we are heard also when digitization comes, and there's really a push for a human-centered AI, not as and a human-centered digitization, and perhaps not as it has been already been coined many times by the European Commission, but truly with people being involved even in the making of the legislation. And the amount of people that are contacting us and want to have conversations about something that sounds kind of difficult, right? Artificial intelligence, what is it? It's something with computers, I don't understand. No, actually people are realizing that it just has impact on their lives, and they want to have a say in it, and that gives me a lot of hope. And I think what this will mean for the upcoming negotiations, which are not going to be easy. I mean, already in the European Parliament, we have to deal with so many different committees who can have a say on it. So imagine how we then go even further in discussing also with the Council and the Commission. But what I do think is that we're seeing that more and more politicians are also talking not only with the tech companies, but really with the people and with the trade unions on this subject. And I think we will be able to force some things into it.
Absolutely, and I should say we've got a comment in from our audience from Nikita Sanula from Eurocities, pointing out that if the pending EU instrument on adequate wages is effective, might lead to fewer people taking on platform work. So there's a lot of moving parts. Unfortunately, we're right at the end of our discussion and don't have time to get into that now. But Yassine, I'll leave a final word to you. What's your call to policymakers like Kim, or maybe those who are less receptive even to your position?
Yeah, I mean, I just want to say, I think, like I said, Kim is doing the right thing, and Layla, but I just think we need more politicians coming out, because it's very important. Because, like I said, you got on one side, you got the big giant corporation. They got unlimited resources. They have that lobbying power, and as Kim rightly pointed out, when something is going against them, they become really aggressive. They start throwing everything around. They got the money and they destroy. I mean, think of it from a worker's point of view. Like, he has nothing. His life is pending on these politicians to come forward and do their bits. The workers are doing their bits. They're fighting in court, they're fighting on streets. So we just need these politicians to come out. And we're not asking for any special favors. We're asking for a fair system. And it's just so important to have this. And like I mentioned earlier on, it's not just about making sure that we could get these laws. It's also about enforcement. Because the problem I had is I shouldn't have had to go through this lengthy 6-year battle while everyone sat back and watched us. The law needs to be enforced. And there needs to be some kind of punishment. And right now, even though we talk about these great laws and stuff, but there is nothing to scare these companies, saying, look, if you break the law, there's going to be some heavy sentences or something. So I think it's just like there's two sides. One is making sure we do have these great laws, and secondly, we need to really look at is how do we enforce these laws. So like a company like Uber, they literally, no one should be above the law, and they shouldn't be able to buy their way out.
Well, thank you indeed. That's an absolutely great point to make, and we hope we will see the sorts of law that we were discussing here today. Thank you very much for the great conversation and for your really great insights. And thank you indeed to the audience for paying attention. We are going to take a 1-hour lunch break now, but we will be back this afternoon with 2 more panels looking at the question of AI and where it can be dealt with in terms of discrimination, and where we can look out for the interests of those who are most disadvantaged in society and ensure that technology does not leave them worse off. The panel we'll be starting at 2 o'clock is Automating Fortress Europe, looking at AI in migration and border control, looking at the situation of refugees and where AI possibly disadvantages them and what could be done in the upcoming law. And we will wrap up later on with a wide-ranging discussion on discriminatory surveillance overall and the EU Artificial Intelligence Act. So you don't want to miss that. We'll be pulling together all the threads from our other conversations in that. So stay with us, stay with Euractiv, and join us again at 2 o'clock. Welcome back to today's conference organised by the Open Society European Policy Institute and European Digital Rights Group, EDRi. My name is Jennifer Baker. I am your moderator for this afternoon to try and draw together some of the threads we've spoken about in this morning and look forward to how the AI Act will look with relation to human rights and fundamental freedoms. Our next panel, we are focusing on Fortress Europe, automating Fortress Europe. In other words, AI, artificial intelligence in migration and border control. Once again, this is about disparities of power and where the most vulnerable can be targeted. And instead of using tech for good, we're actually making the most vulnerable even worse off. And we're going to look at ways in which the AI Act might be able to mitigate these problems. Joining me, I am delighted to have Petra Molnar, the Associate Director of the Refugee Law Lab at York University's Centre for Refugee Studies. A lawyer and researcher, she specialises in the impacts of migration control technologies on the rights of people on the move. Alina Smith is Deputy Director of PACOM, that's the Platform for International Cooperation on Undocumented Migrants. And last but not least, Peter Vitanov is a member of the European Parliament in the S&D, the Socialists and Democrats group, and he is the shadow rapporteur on the AI Act in the LIBE Committee, that's the Civil Liberties, Justice and Home Affairs Committee. So very glad to have all three of you with me today. I'm really interested to hear about what sort of work is being done on this specific sector with relation to AI, because we already know that undocumented migrants face an uphill struggle. And in some cases, one might think, well, documenting them, getting their data, storing it and processing it might be a good thing. But that's not always the case. Petra, what have you been looking at?
Thank you so much for having me. It's a real pleasure to be here for such an important conversation. And I'm really, really glad that we're discussing the impacts of technology at and around the border. I'm a lawyer and an anthropologist, so I look at the lived experiences of people who are crossing borders and seeking asylum across a variety of jurisdictions. And most recently, I've been trying to understand the sharpest manifestations of border surveillance on people on the move. I'm based in Greece these days, and I've been tracking and trying to understand this kind of growing ecosystem of these migration management technologies and their human rights impacts. And we really are talking about an ecosystem that is increasingly kind of weaponized against people who have a fundamental human right to seek asylum. We're talking about proliferation of automated drone surveillance, different types of projects such as AI lie detectors, more kind of traditional surveillance that we're seeing, and some really, really far-fetched ideas too, such as really violent sound cannons that are being rolled out across different borders. But again, it's this foundational idea that we're seeing people on the move being used as a testing ground for really, really high-risk technology that will then be rolled out in other contexts as well. And unfortunately, given the kind of appetite for the development and deployment of AI-type technologies, this is only the beginning, and likely in the coming years, we're going to be seeing even more technology in this space.
Thank you, Petra. As I'm hearing your terms, that it's almost like a gateway. But Alina, let's stick to those harms that are suffered by the undocumented migrants and refugees.
Thank you very much, Jennifer. I think maybe an important place to start is actually, as a backdrop to also what Petra was saying, is that one of the basic harms we see is the very premise behind the increasing use of technology and AI in the migration context. And that premise is basically about reinforcing the notion of threat or danger. So we need to augment the use of these different tools at our borders in another context that I'll mention in a moment, because we need to counter the threat created or caused purportedly by these people, these men and women and children who want to come into Europe. So that is a harm. And what is the harm there? Again, it's reinforcing stigmatization. It's reinforcing the demonization of certain types of people who want to come into Europe, who want to reside here. And I think this is in addition to kind of the broader harms around fundamental rights, some of which Petra was mentioning a moment ago. If I can briefly just actually quote the European Commission itself from 12 years ago in a report where they said a single overarching EU information system with multiple purposes will deliver the highest degree of information sharing, but creating such a system would constitute a gross and illegitimate restriction of individuals' right to privacy and data protection and pose huge challenges in terms of development and operation. So 12 years ago, the Commission was saying we'd love to have an interconnected, unified system, a set of information systems for migration control, but gosh, that would be a terrible thing for fundamental rights. And what we see is that just less than a decade later, in 2019, we have the interoperability regulations creating an interconnected set of migration databases for the joint purposes of tackling irregular migration, but also serious crimes like terrorism, again, underscoring this idea of threat and danger linked to the very fact of being a foreigner. And maybe if I can just say very concretely, in addition to the harms in the context that we see that Petra was mentioning at our borders, we also see the growing use of technology for immigration control inside our borders, and I would even say inside our communities. We have police in the Netherlands, for example, that on handheld devices, when they stop someone, can see at a moment's glance what their address is, what their status is, and communicate that to the immigration authorities immediately. And similarly, in Greece, we see that there are EU-funded initiatives to really strengthen the ability of Greek police to stop people and identify their status, their irregular status, and do an immigration control on the spot through the use of this type of technology. And we heard even last month at a conference that a high-level speaker from the European Commission expressed his enthusiasm, or at least his belief in the opportunities and the potential of using surveillance technology for social media monitoring to assist migration preparedness. So this goes far beyond the use of technology at borders and harms, as concerning as those are in the context of our borders, into our communities and even into our virtual spaces.
Well, thank you. Let's turn one view on this. Tell me, what is the current thinking in the LIBE committee?
Oh, thank you first. I hope you can hear me well. Thank you for giving me this opportunity. Oh, this is an extremely, extremely important topic. Although, as you probably know, the LIBE committee was way after IMCO committee was part of this whole process, so we had less time to get organized ourselves, and as you know, we share competence with IMCO and LIBE, and actually we are just in the beginning of our debate. But allow me maybe to share some of my concerns, because yes, the AI Act is something extremely important because AI is all around us and it's growing exponentially. But at the same time, I share some concerns when we speak about the usage of AI in the field of migration and border control. Yes, if you allow me, I will just point out briefly some points, and then maybe we can speak about them later. Or first, I'm very, very skeptical on the added value of usage of some techniques, such as polygraphs or tools that detect the emotional state of person. There is simply not enough scientific evidence that these techniques actually work. They also affect disproportionately vulnerable people. So if you're simply nervous or scared to fly or scared to be questioned at the border or have some neurological conditions that affect your involuntary movements, then you will be targeted by such software. So I believe that these unscientific practices relying on the idea that a machine can never be wrong should be directly banned under Article 5. And this is basically the view of the EDPB and EDPS. Maybe on the other hand, strengthening the Article number 5. Well, right now there is no mention of the harms of practices like predictive policing. This was an issue that we've been discussing in the report of the AI in the law enforcement. This, which has demonstrated evidence of disproportionate transgression of the fundamental right to non-discrimination, the presumption of innocent or child rights. We paid huge attention on that one, but I believe that it should be also put in here in the AI Act as well. Also, something very dangerous, I would say, the proposal prohibits social scoring, of course, when performed over a certain period of time or by public authorities or on their behalf. However, private companies such as social media cloud service providers can also process vast amounts of personal data and conduct social scoring. So I believe that we should look more into this, and the future AI regulation should actually prohibit any type of social scoring. And this is also agreed and approved by EDPB and EDPS. Also, when we talk about biometrics, because of course it's linked with the question here, Article 5 deals with the prohibition of real-time remote biometrics identification systems in publicly accessible spaces. Now, it also leaves the door wide open for exemptions such as, I quote here, prevention of specific substantial and imminent threat to life or physical safety of natural persons or of a terrorist attack. Well, you can imagine such an exception seems quite vague to me, and with a lot of possibilities for wide interpretation by all the authorities. And then maybe another loophole, the ex post use of biometric identification, which I fail to see how it would be a benefit to citizens, right? If we agree the practice is harmful, then it doesn't matter when it occurs. Judicial oversight over these practices could be postponed in case of urgency, which is again too vague and subject of wide interpretation. And maybe last but not least, such use of AI involves processing of data and indiscriminate and disproportionate number of data subject for the identification of only a few individuals. Not to mention that there does not seem to be enough evidence that this actually works. But imagine if we have to place millions under surveillance, breach their rights to privacy and anonymity in the public space only to get 1 or 3 suspicious individuals. Is this really worth it? So these are basically some of my concerns. Of course, I can go on and go on, but I'll be glad to have more or less a discussion on that. Thank you.
Thank you, Peter. And I would remind our audience, of course, you can ask questions of the panelists. Just put them in the chat box and we'll try to get to those before the end of our hour's discussion. Petra, to come back to you, you mentioned these different migration management technologies. Could you break it down for us a little bit more, what the specific types are and how they're used in different parts of the EU?
Sure, I would be happy to. And I think the term migration management is an instructive one because, again, it illustrates the broader logic that we are talking about, that borders and migration are something to be managed and controlled, and again, kind of reify the big power differentials that we're seeing at and around the border. Because again, the ecosystem in which we're talking about really matters here. We're, for many years now, seeing a sharpening of borders, anti-migrant sentiments, a rising xenophobia, and also strangely now, of course, with the invasion of Ukraine, also a lot of solidarity, which once again highlights this kind of differential way that people migrate and experience the border. But when we're talking about migration management technologies, we're talking about a broad class of applications that, as Alina reminds us, are not just about the border, but also what happens before a person might cross a territory and then also afterwards. But for me, what helps is to think about it temporally, perhaps tracing a person's journey as they're moving from their homeland into another place where they want to be. And a lot of issues can occur even before a person crosses a traditional border. So things like social media monitoring, for example, or predictive analytics that are increasingly used both by states and state actors, but also by international organizations to try and use big data analytics to forecast where people might be moving after a conflict and where aid might be most useful. But also the concern with predictive analytics, of course, is that it can be co-opted for interdiction measures or pushbacks, which are illegal under international and domestic law. And then at the border, kind of the traditional space where we're seeing a lot of this sharp surveillance and automation occur, we're talking about unpiloted drone technology, thermal cameras, sound cannons, which are, for example, being rolled out at the Greek-Turkey border. We're seeing in the Greek refugee camps a vast array of automated surveillance technologies, including motion detection algorithmic software, and even playing around with virtual reality. And then all the stuff that happens after you cross the border that Alina was reminding us is, of course, also important to talk about. We're seeing an increase of automated decision-making in refugee and immigration applications, all sorts of risk profiling, and of course the conflation between criminal justice and immigration enforcement too. That is something important to think about. I mean, this is just a smattering, and Petar also talked about one specific example that I think is quite visceral, and that is the use of polygraph type technologies or lie detectors, essentially, which there's a big appetite to introduce them at and around the border. But to me, this particular example of a migration management technology really shows so many of the pitfalls that we need to be discussing. And often this can seem so kind of up in the air and theoretical, but this particular case study there's something really visceral about it. And I just want to end here. You know, when we're talking about, for example, lie detection, which we know is something that inherently is faulty, and the traditional lie detectors, you know, that we see on TV and in courts, sometimes they're not even admissible in jurisdictions, in courts of law. So the fact that we are now introducing AI type polygraphic technology on the most vulnerable, in these most high-risk cases, is really, really telling. Why are we doing this? What are the priorities? Because, again, migration is seen as something to be managed and controlled, and the border is something to be fortified. And these types of discourses is something that we have been seeing for many years in the European Union space. And the Fortress Europe idea is unfortunately strengthening with each coming day as we see more and more technology being used in this space. So again, it's about borders, but it's about management. And again, that kind of broader logic that underpins this just really reinscribes the vast power differentials that we see between the people who are actually migrating and crossing borders and those who are making decisions about them.
Thank you. Alanya, you mentioned there the tendency to conflate terrorism with non-Europeans and with people coming from the outside and foreigners. This is, one might think this is quite a cultural problem, and we're trying to look at it from a technological point of view. Can the AI Act, as it's currently envisaged, actually help solve this problem? And does it do enough to safeguard fundamental rights? Are we dealing with the source of the problem, or are we dealing with the potential solutions to the problem? I'd like you to drill down a little bit into that, about where you think the levers for change might be.
So I think it's important, I think what you've mentioned, to really emphasize that we have technology and then we have the context within which the technology is applied. And in the migration context, it's already a context where, as we've already heard, there are enormous power differentials. What is at stake for people is enormous. And there's already an infrastructure attempting to really control in significant ways people's movements and so on and so forth. And so we have the use of technology to really augment pre-existing efforts to do that kind of deterrence, to do various types of risk analysis, and so on and so forth. So I think technology, the context really matters here. The context really matters here. So does the technology make a difference? Yes. Is the technology fundamentally the problem? Well, the broader context is already one where we already see there are already important concerns about the risk of fundamental rights violations and that actually happening. So what can the AI Act do? I think, first of all, it's very interesting and notable that a number of different uses of artificial intelligence in the context of migration and asylum are recognized in Annex 3 of the AI Act as high risk. So what does that mean? High risk to health and to fundamental rights. So this is already a recognition of some of what we've been talking about. So that's important. So I think the AI Act is already important in recognizing the potential harms around the uses of technology in the context of migration and asylum. I think at the same time, what does it mean that some of these uses have been identified as high risk? Well, actually, what it means is that the consequences around that designation are mostly technical. It mostly have to do with increased transparency and certain types of technical fixes in terms of a focus on data and quality. What it doesn't mean is that we actually need to take more care and pay more attention to the impact of the use of those technologies and take any steps to either stop or mitigate a harmful impact. So I think the opportunity of the AI Act is not only to designate certain things as high-risk uses, like migration in the migration context, but to actually have consequences for those designations that mean that there has to be an assessment of impact of the use of those technologies and measured ways in which the impact can be stopped, or the harmful impact can be stopped or mitigated. And there also needs to be something that's not there now. In recognition of the impact, there has to be, I think, an opportunity for personal redress. There has to be personal rights that allow people who are negatively harmed or impacted to actually have some mechanism for accountability and redress. So I think that's also really important. And of course, the transparency aspect is critically important because so much of how technology is deployed in the migration context is invisible. It's in migration procedures, as Petra was saying. It's in risk analysis and assessments. It's in apps being used by different authorities to share information and to make decisions in ways that people often don't have any idea about. And so it's extra important, I think, in those contexts for people to understand and to have transparency about how technology is being used in ways that affect decisions that are being made that have enormous implications for their lives. So I think there are really important opportunities with the AI Act. I think what's already in there has some promise, but we still need to do work to really strengthen it to make it meaningfully protective.
Peter, let me come to you and ask you, we've had an MEP on each of our 3 previous panels, and I've asked each of them, what is this sort of lobbying like at the moment, and what sort of positions are you hearing? Maybe not just your own position, but what are your colleagues from maybe different groups? What sort of proposals are they being presented with, either to water down or to strengthen the AI Act?
Well, of course, it depends. I really do not want to speculate on that topic. But let me tell you, the main focus of the LIBE committee is how to make that AI Act to serve and to protect the fundamental rights. Like the fundamental rights is our main focus. Of course, maybe IMCO committee deals with the safety of the product and so on and so forth. But to us, it is really important that all these technologies, they should serve to the people, because very often we are presented with this false division that we have to choose between the innovation and fundamental rights, and we cannot have both, and the more you go with the one, the more you lose with the other. But I really don't think that it is the truth. We must foster innovation that is compatible with fundamental rights. I read something very interesting in the social media, because good example, just because cars runs with 250 kilometers per hour, this has not stopped regulations from imposing driving speed limits for reasons of public safety. And in other words, just because some techniques exist and are possible, it doesn't mean that they should be accepted. And the same goes maybe with some other false distinction, security versus freedom. I mentioned something in the beginning. We will not get more security if we rely on completely unscientific and mistake-prone technologies, nor we would get it by normalizing mass surveillance. Humans will always be smarter than the machines, and AI is not a silver bullet. We all know it, that will solve all our security issues and concerns, and suddenly there will be peace all around us. Of course, it's not the case. On the contrary, think about how attempts to identify and classify people according to their physical characteristics, in particular their faces, have a long and troublesome history. It was not so long ago when there were serious people and scholars who believed that the size of your skin or the shape of your nose was an indicator on whether you are higher race or smarter, or so on and so forth. I think that kind of thinking did not bring security to anyone. But maybe to wrap it up, my biggest aim would be to protect the fundamental rights, because in this piece of legislation, we see certain loopholes that might affect the fundamental rights, and it will be our main goal to try to avoid them. Thank you.
Well, that's clear. Thank you. Petra, let's move on to the question of not so much the collection of people's data, but the storage of it, and these huge, massive, large-scale migration databases, the so-called Schengen Information System, for example. They create a threat landscape that could be create vulnerabilities. But what are the other issues around that you find problematic?
Yeah, definitely. I mean, the kind of underpinning that we really need to look at when it comes to the datification of migration or even the humanitarian response is such an important element to this, because increasingly, and this has been happening for many years now, there's this turn towards thinking that more data is always better. And the issue with these giant databases that are being created now is that a lot of them are going to be or are already interoperable, meaning that data collected for one purpose may be repurposed for a whole other type of use case. And we, again, this kind of conflation between migration and criminalization of migration that Alina was reminding us is something really to keep in mind. And the more data that we have, the more problematic inferences we can make about somebody, because again, the context really matters here. We know that when we're talking about immigration decision-making, refugee processing, these types of decisions are already extremely opaque and discretionary when just a human officer is making a decision, right? You can have the exact same set of evidence in front of two different officers, and they can make two completely different determinations based on the data that's in front of them. Now imagine that we are starting to collect more and more data, putting them in these databases that are potentially being used to automate or augment human decision-making. It becomes very, very complicated to parse out why particular decisions are made and why they might be discriminatory. Because again, we know that the immigration system and border regimes generally exacerbate systemic racism, vast power differentials, and really, really problematic decisions. So the more large databases that we have, the more interoperable they are, the more kind of data sharing that happens also without appropriate conversations around data protection and different types of safeguards, we really are creating a whole vast array of potential rights abuses, both from a fundamental rights perspective, but also from an administrative perspective, because it gets really complicated to challenge something when we are increasingly relying on large storages of data, which are then used, for example, for automated decision-making in this context. So again, the fact that we're talking about immigration decision-making, refugee processing, two areas that are already opaque, already discretionary, it's very, very worrisome that this turn towards datification, as some people have called it, or techno-solutionism, and the creation of these large databases is really, really concerning. But again, the appetite is there, and we are going to be seeing more of this in the years to come.
Thank you. We've got some questions coming in from our audience. Christina is asking about the implications of the deployment of AI tools at the different stages of asylum procedures in refugee status identification. Alina, perhaps you could mention that as well within the context of these large-scale databases.
Sure. So, as has been mentioned, what we see is the increasing use of different technologies in different procedures. And so, for example, in the German context, there is the use of software to analyze whether a person who has applied for asylum, to analyze their dialect. So if they claim to be from a particular region of a country, there's a software that can be used to analyze whether their dialect actually matches the alleged region. And this maybe sounds like a great way to make perhaps a difficult decision more objective. But I think there are a number of ways in which we really need to think carefully and maybe critically about this type of use of technology. First of all, the evidence is that this type of technology is not entirely reliable. And so we are actually not entirely sure how effective that assessment is. But at the same time, at the bottom of this type of systematic assessment of dialect is a profound skepticism about the credibility of the person in front of us. And so I think, again, it reinforces this idea of people really mostly not being credible, mostly not being kind of authentic or bringing bona fide claims. And it introduces a systemization of an assessment that one has to worry how effective it is. And also we don't know the extent to which, as Petra was saying, it gets very complicated. When this is one piece that's brought into a decision-making process, the fact that it seems objective from a machine just as by human nature, we might be inclined to weigh it more heavily than we might otherwise do against a range of other factors that we're considering. So it might really have an outsized weight in that whole processing. So I think there are a variety of ways in which we really need to think carefully and critically about how we're using technology in these different contexts. When we speak about the EU's IT migration systems, perhaps we'll come back to this in a moment. This is an EU level kind of information technology architecture that is profoundly complicated and connects up with member states' national level migration systems. And so it introduces a massive overlaying new layer of complex IT architecture on top of what already exists at the national level, and brings together pieces related to asylum, pieces related to criminal law, pieces related to visa applications, things that you would think, gosh, have nothing to do with each other. But as Petra was said, by making them interoperable, we then can refit the purpose for which a particular piece of data was obtained to meet another purpose, or cross-check data against data, for example, in a criminal database. So again, the complexity of these systems is profound, and the opportunity for them to be generating errors is also something we need to bear in mind. And given their complexity and their opacity, how do we even account for those errors? How do we have accountability for those errors? Again, in contexts where there are enormous implications personally for the individuals involved.
Well, to deal a little bit specifically and technically with the AI Act, Article 83 creates this exemption. It lets the Schengen information system off the hook for all the other checks and balances that we might want it to. Peter, what's your views on that, and specifically that article?
Well, my personal view is very simple. I'm honestly, in general, I'm against all kinds of exceptions, and I told you why. Because in these exceptions, we see a lot of loopholes that can be a subject of a really broad interpretation. And we have seen that many national authorities take advantage of that kind of interpretation, not only in the least developed countries or in the countries where the level of democracy is low, but also in the, I would say, one of the most democratic countries as well. So basically, frankly speaking, about Article 83, I'm totally against. I believe that this act should be valid for everybody. And it's not only about the loopholes, but what example you give to the European citizens. You cannot exclude European systems, because you cannot, if you exclude them, this will be additional mistrust in this system. And you know it, when we speak about the biometrics, we now have a EU centralized information system for borders and security, and they're increasingly incorporating biometrics technologies for the purpose of verification, identification. Now we have fingerprint identification technology used in 3 different systems: SHIS, Eurodac, and VIS, and it will be incorporated and implemented in ECRIS and in entry, and exit system. So I believe that this AI Act should be valid for all European systems. This is the only chance and the only way that we can build trust among the European citizens.
Alina, let me come back to you on this specific act, Article 83 of the AI Act. What's your position in terms of its potential to remain in the final text, which of course we don't yet know?
Well, I think first of all, its existence is striking. In particular, as I was mentioning before, because certain uses of AI in the migration and asylum context are explicitly recognized by the same act as high risk. And yet the EU then promptly excludes the application of the act to uses in the migration context of its own databases. So I think it's very striking. It's not entirely surprising, unfortunately, because of course we saw that these interoperability regulations that we were mentioning a moment ago, these regulations that came in 2019 to create the interconnectedness among a variety of different migration databases. Well, those came into being barely a year after the GDPR. The EU's effort to really set the gold standard on data protection. And lo and behold, we have these interoperability regulations that fly in the face of that, again, purportedly, well, explicitly to address immigration, irregular migration, and serious crimes. So again, I think we have this striking, shall we say, incoherence, where we have a piece of legislation that really attempts to set a global standard again on artificial intelligence and fundamental rights, that then promptly exempts some of the most concerning uses in the immigration context. So I think it shouldn't be in there. At the same time, we already know, as we were hearing a moment ago from Petar, that some of these systems already foresee precisely some of the problematic uses. And so in a sense, it would mean unwinding existing plans. And unwinding existing energy and zeal to actually deploy technology even more in the migration context. But of course, it's incoherent. And as we were hearing, it undermines the very kind of premise of the act itself. So I think it really has to be removed, Article 85. Now, the likelihood of that, or pardon me, Article 83. The likelihood of that, I think, again, given the politicization of migration, given the tendency to view migration through the lens of security, to exceptionalize in all the negative ways, application of rights, fundamental rights in the context of border management and immigration control, I think it will be a challenge to see that this article will be removed. But I think it's incredibly important that that we work to see that it's removed from the Act, to ensure the coherence, and to ensure that it really stands for what it says it does, and to really meaningfully start to address the harms that we know already linked to the uses of technology in the context of migration policies, procedures, and practices.
I think also it's worth saying that it's a little bit do as we say, not as we do, and would leave the EU open to charges of hypocrisy, something we saw very much in parallel with the General Data Protection Regulation, where, for example, the US said, yes, but EU states also spy on their citizens, so don't preach to us about what we can and can't do with data. I see that coming down the line. I've also got a very interesting question in from an audience member, Petra. It's broadening out a little bit beyond the AI Act, asking what responsibility do social media companies have to combat or reinforce the sort of fundamental rights and these regulations as they're coming up? It's an unusual take, but I'd be interested whether you've got a position on that.
Thank you for that question. I think that's actually really excellent because it gets at something that we have not discussed much today on this panel, and that is the role of the private sector in all of this. Because absolutely, I mean, not only do we see this proliferation on part of, let's say, state actors to want to do social media monitoring using a lot of these social media companies, you know, tapping into people's phones as they're on the move, trying to make all sorts of risk profiling as a result of online activity. But then when we actually break it down and look at the responsibility of private sector actors, that is such a huge puzzle piece in this whole conversation. Because for me, actually, this is something that, as I try and understand this kind of growing political economy and the border industrial complex, as some people call it, with this proliferation of migration management technology globally, the private sector plays such an important piece, because it's not only are we seeing this increasing over-reliance on the private sector when it comes to the development and deployment of technology, because oftentimes states are not able to themselves develop the technology that they want to use in-house. They need to use private sector actors to be able to do this. But of course, from a legal perspective, a private sector actor has very different responsibilities to an individual or a community that's harmed and affected by technology. And what happens often is what some people call responsibility laundering, where A public sector actor like a state or a government department can say, well, you know what, actually this rights infringement is not really under our purview because it's as a result of the private sector actor that we're working with. And the private sector actor can say, well, it's not really our problem either because we just developed this tool and then we passed it off to the state. And it creates this vacuum where individuals and communities really can fall through the cracks. But, you know, I think it's also about broader questions, though. It's about whose priorities matter when we start developing and deploying technologies in this high-risk space. You know, why are we developing AI lie detectors to be tested out on refugees and people crossing borders? Why aren't we using AI to root out racist border guards? There's a clear differential in terms of why certain innovations get pushed through, and the private sector bottom line, as in making lots of money in big tech and big migration tech, that's very, very clearly a motivating factor why this ecosystem is allowed to proliferate the way it does. So I think it's a really excellent question because it highlights yet another important actor in this whole milieu that we really need to keep a close eye on, both in terms of the responsibility, but also the priority setting that we are seeing.
Well, staying with this question of the private sector, another question from our audience is asking, do you think there might be other levers against private firms selling border security technologies beyond the AI regulation as currently defined in the AI Act? Petar, do you see any other, at EU level, ways in which we might mitigate some of these harms?
Did you ask Peter or Petra? Peter.
Hi, as Peter.
Oh, is that...
Peter.
Okay. Now, in order to mitigate, we should identify the problems. And I think that one of the biggest problems that we are having here is the future proof of this piece of legislation, because it will take years before this legislation enters into force. First of all, you know that the legislation process is very lengthy in the European Parliament. Then after adoption, it needs 2 or 3 years to take time. Because Alina was speaking something about the high risk. And in my opinion, we should make this legislation future-proof, because it will enter into force in 2026, and nobody knows what the situation in 4 years' time would be. So in my opinion, we should look for ways to put more flexibility in terms of adapting these risk categories. Because Alina mentioned something about the high risk, and something that we consider today low-risk usage of AI can review to be actually high risk, or even unacceptable in a couple of years. And I think that we should really pay attention on that, because we need to have a flexible possibility for adaptation. And according to the design and the proposal of the Commission, we don't have such now, because the Commission suggested using delegated acts to amend Annex 3, but only with these 8 headings defining possible areas. So, and maybe another issue that we missed, this is a huge challenge also for me, how to ensure that people have the right to complain if their rights are being breached, because we are talking about the breaching of human rights here. The Commission proposal spoke a lot about the providers, about developers of AI system and new users of AI system, but does not mention the subject of AI system, those like me, like you, who might be profiled by AI, whose data will be examined by the AI. So I think that these are also issues that should be raised and should find a proper decision. Thank you.
Marta Caballero has written in to ask, do you think that once these systems are deployed, they acquire a momentum of their own, creating the need for yet more technology? I'm going to take a guess that probably all of you on the panel do see that as an inherent problem. Anna, another audience member, is also asking, does the EU digital IT investment in Africa feed into this tech-focused vision of Fortress Europe? And how can this approach be challenged in European institutions? Alina, let me put that one to you to talk about the sort of, if you like, the export of these ideas or export of this technocratic solution.
So many of you may well know that the EU's efforts to deter irregular migration, or to deter migrants from leaving certain countries and entering the EU, also involves working with third countries. So it's not only about developing policies concerning EU borders directly and interior to the EU, but it's also about this notion of externalization, so really working with third countries. So it is the case that, of course, in this context, that discussions about and explorations of the use of technology to again augment these types of initiatives or these types of agreements is definitely a reality. And so I think that's something we also have to bear in mind. So, and when we're speaking, as we've heard before, about asymmetries of power, we also have to bear in mind that is also the case when the EU is dealing bilaterally with some of the countries that we're that these third countries. It's a case of asymmetries in terms of their ability to actually push back, but there are also concerns about some of these third countries not necessarily themselves being very respectful of human rights. And so the ways in which then technology might be used in those contexts might be also deeply problematic. And so I think when we layer on this international dimension, this externalization dimension, we really do see the complexities and the concerns about the EU's enthusiasm about using technological solutions as a way to augment the ways in which we try to discourage people, deter people, monitor people, surveil people, and so on and so forth. So in terms of what we can do about that, I think part of the problem is that a lot of this, again, is very intransparent. And we really need to see what we need to press as much as we can for greater transparency in terms of the types of discussions that are underway. I think Petra is exactly right to use the term ecosystem. We have a number of different actors who are involved in this whole conversation, in this whole deployment around technology in the migration context. We have governments, at the national level in Europe, we have the EU level actors, we have private sector actors, and of course we have affected communities and individuals. And I think there's a lot of lack of transparency about how decisions are made, about the nature of the negotiations that are underway, about how agreements are made. That makes it very, very difficult then to speak in terms of accountability. So I think that's one thing. And the other thing is really to really start to be much more, to really visibilize the fact that that this is happening. And that all of this is deeply harmful and part of this broader infrastructure that is really, as we were speaking about momentum, is really going to move. The likelihood is it's going to move in a direction towards more deployment. So I think all of us need to be mobilizing around these issues, and it really needs multiple actors to really be calling for greater transparency and accountability.
Well, I've called them technological solutions for want of a better phrase, but perhaps I should be saying processes, because of course solutions presupposes a problem and possibly underlines some of the issues we're having when discussing migration. A final question, we're on a wrap-up point, and I do want to just take stock and take note of the current situation with regard to the Ukraine influx, as it were. And we are seeing an unprecedented waiving of the controls that we would normally see in place at the border there. I'm interested to know, from your point of view, do you think that this may have a knock-on effect, that we may see member states saying, well, actually, maybe some of these controls that we put in place were not necessary, that they were too extreme, since it seems that Europe is more than capable of coping with a huge refugee crisis like we see in the Ukraine when there's enough public will behind it. Petra, I'd like your thoughts, just a couple of minutes as we wrap up, on what that might be the fallout from this current situation.
Thank you, Jennifer. And I will keep it brief, but this question actually means a lot because I was just up until a few days ago at the Ukrainian border doing some evidence collection and just trying to see what the situation is like. And you're absolutely right. I mean, I think the situation highlights how it is very possible for Europe to really lean into the deep solidarity that it is capable of and to open borders and to allow people fleeing the situation and the occupation towards safety and to exercise their internationally protected right to asylum. But once again, it also highlights just how differently borders are experienced depending on your skin color and your place of origin. Because if we take Poland as a direct example, we've seen an amazing outpouring of kindness, solidarity, resources, and open door policy, so to speak, at the Ukrainian-Polish border. And yet just a few hours north of that, at the Belarusian border, we continue to have people trapped in a corridor where they're not able to cross into European territory and claim asylum. So again, borders are always differentially experienced. And the concern, I think, is that technology exacerbates these power differentials. It remains to be seen what Europe decides to do moving forward, given the current situation. And I'm trying to be hopeful to see whether this will perhaps be a bit of a change in the discourse around migration, around open borders, around the harm that sharp border technologies are perpetrating on people and communities. But given the ongoing differential experiences and flat out racism and discrimination that is being experienced, even in this situation coming out of Ukraine, I am not as hopeful as I would like to be. So I think the coming weeks and months are going to be quite telling, and it does map on to in interesting ways, given how the AI Act is also being developed. So we'll see if there's opportunities to push it further and introduce some more conversations around humanity, dignity, and again, protecting people's fundamental rights as it comes to asylum and also just freedom of movement, generally speaking.
Thank you. Peter, there's very often a mismatch between the member states at the council level and what the European Parliament wants to do. It's not exclusive to the AI Act by any means. But as I've mentioned the Ukraine, we are seeing a very different shift in the viewpoint of certain member states, of certain governments in this opening up and solidarity. Do you think it's any chance of that having a knock-on effect to the inevitable negotiations between the Parliament and the Council further down the line? Or do you think those traditional disagreements will still remain?
You mean in the AI Act?
Yes.
The kickoff effect from Ukraine to the AI Act.
Yeah.
In the migration board, I wouldn't say that. I mean, yes, the situation that we are having in Ukraine is kind of unique because it shows the European solidarity. But when we speak about the European solidarity, we should speak also about the European hypocrisy. Because when we have certain type of migrants or refugees, some of them we give the keys to our own houses like we have now with the Ukrainians, but at the same time, some other with different color or different religion, we keep them away from the European borders. And we scare them with all kinds of border control, so on and so forth. And so I think that this crisis in Ukraine might bring us to a necessity to change and it is a possibility to change the politics, the migration politics, because it's not been solidar so far. Now it gives us a chance to show not only with the Ukrainians, but in general, those who really flee from war, they should be treated equally. So from that perspective, I assume and I expect a bit more openness. But as to the AI Act, I'm not really sure that it will directly affect the process, the processing, and the border control. This is just a technical solution, I would say. This is not and this technical solution is done for purpose. But I think that this is the right moment to change the migration policy of the European Union.
Alina, am I making it too much of a stretch to hope that the current situation might have a silver lining?
I would just echo what others have said, that I think in the midst of this moment of solidarity, we just see an extraordinary contrast in what's happening in terms of responses to others in situations of need. So I think, like others, my hopefulness is a little bit mitigated by the reality of those discrepancies and inconsistencies. That being said, I think it is for us to use the opening to really see what the opportunities are for a shift in the conversation about migration. I think the problem too often is that people work with an idea about what a good migrant is, the right kind of migrant, and of course, the most, shall we say, quote unquote, deserving migrant is often the one that is kind of the innocent migrant fleeing force, fleeing violence. And other types of migration or other types of migrants are much more easily vilified. And I think even in the context of the Ukraine situation right now, I think, again, we need to see, because over time, as the situation maybe changes, and as some people, some Ukrainians maybe remain in the EU, the EU itself is predicting that perhaps as many as half Ukrainians may not apply for temporary protective status. And so over time, people may remain, the situation may change, and they become undocumented, or perhaps they settle, and do attitudes then change? And so I think there's a sense in which there is an opportunity maybe for us to really try to shift a conversation about how we understand migration, but we all need to really query and question and critique our ideas about the good migrant, the kind of deserving migrant, and the ways in which that notion is often idealized and extremely exclusive, so that those who don't fall into those boxes at a moment in time, as we heard, are at the sharp end of our immigration policy. So I do hope that this can be a moment to shift the dialogue and to have a much more nuanced discussion about mobility, about movement, and about our attitudes about those who want to come to Europe for whatever the reason is.
Well, we're just about to wrap up, so I'm going to be very strict and give you each 1 minute to express that hope. Alina, for the AI Act, what do you want to see from the policymakers? Alina, I will let you go first in 1 minute if you can.
All right. So I think, again, for me, the three critical things maybe to take away in terms of the AI Act in the context of our discussion today on migration. The first thing is simple. Let's remove the exemption for EU migration databases. It's, as you said yourself, Jennifer, I think it's unfortunately just blatantly hypocritical, and we need to do better. So let's just remove that exemption. Number two is, let's make it meaningful to designate something as high risk. Let's make it not only about fixing the quality of data, technological fixes, but let's actually make it meaningful in terms of an assessment of impact and opportunities to mitigate, limit, or even stop certain types of uses that are harmful. And finally, let's make it possible for people to actually have recourse where their violations of their rights occur in the context of the deployment of AI, in the migration context or another context. Let's make it possible for individuals to have rights under the Act to seek accountability.
Peter, your 1 minute takeaway, please.
I have nothing more to add. I would just like to thank you for giving us this opportunity. And of course, like I said, it will be very important where we will put that line. Because, like I said in the very beginning, our main goal is to make sure that all the fundamental rights are protected. And this AI is only to serve to the people, to the European citizens. So without saying that we should ban all the technologies and innovation, just they should step back and to pay attention to the people and to their fundamental rights. And I hope that in the end, we will be able to find this thin balance between the innovation on one hand and, of course, the fundamental rights and freedoms of the people. Thank you.
Petra, you have the tough job of going last and not trying to repeat everything that's already been said.
Thank you. I think at the end of the day, it's not really about technology. It's about power. And it's about participation and who gets to ask the tough questions that need to be asked. Because at the end of the day, right, it's about who gets to participate in conversations around what counts as technology and innovation, and which communities become the testing grounds on which technology is kind of experimented on. So really, what I would like to leave you with is just the importance of centering the lived experiences of people who are at the sharp edges of this technological development, to include their experiences, include their voices, and invite them to forums like this as well to have these kind of discussions. Thank you.
Thank you very much. Thank you all three of you for this fascinating discussion and for the audience for their insightful questions. We're going to move on now to our final panel of the day. As Petra says, we're talking about imbalances of power. And our first three panels have focused very much on those areas where we can see that clearly, whether it's between the average citizen and law enforcement, whether it's between workers and the sort of platforms that manage that work, or whether, as we've heard, it's against vulnerable refugees and migrants. Our final panel is called Discriminatory Surveillance and the EU Artificial Intelligence Act towards a Rights and Justice Approach, where we're going to try and pull together the threads of everything we've heard and come up with what we think might be sensible advice for the AI Act going forward. And I'm delighted to have joining me Sandra Chandler, one of the key movers and shakers behind today's event, a Senior Policy Advisor at European Digital Rights. Alejandro Moledo is the head of policy at the European Disability Forum, and that's an umbrella organisation that defends the rights of persons with disabilities and defends over 100 million people in Europe. So we need to bear in mind, we are not talking about minorities here. We're small minorities. We're talking about really a huge bunch of people. Brando Benifei is a member of the European Parliament. I think Brando is having some trouble connection, but he is with the S&D group and is a rapporteur for the Internal Market Committee on the AI Act. And finally, last but not least, we're delighted to have Wojciech Wierowski, the European Data Protection Supervisor, and one who has followed these discussions very, very closely. Sarah, I'm going to give you the floor first for you to reflect and set out your stall and what you think you've heard today that has been really key and interesting, and where you would like to take the conversation over the next hour or so.
Yeah, definitely. And thank you so much, Jennifer, for moderating this marathon event that we've had today. Many panels talking about essentially the same thing, which is structural discrimination and AI. Just to say also thank you to the fellow panelists and also to all of the other amazing speakers that we've had here today. Honestly, really, the ethos and what we thought along with OSEPI when we tried to put together this panel is, how do we have a conversation between those directly affected by these sort of sharp end, to use Petra's words, of technological discrimination, but also the people that have the power to make the decisions to change some of this. And really, that's where we would like to go today. I'd like to really kick off the conversation to talk about the framing of AI and discrimination and how we've currently seen that question framed in the policy debate in the European level. So really, so far, I would say that the framing of the question of discrimination and AI has mostly been dominated by this question of bias in data sets. What we've really been trying to do at European Digital Rights, or EDRi, is debunk this idea and say, actually, there's a much bigger and broader problem, and that is how AI is used and how that makes structural inequalities that we already see in our society worse. We commissioned last year a report by computer scientists at Technical University Delft called Cedar Gerses and Agathe Verlaine, who looked into that topic and framing a lot more. And what they essentially said to us is that to truly address the question of AI and discrimination, it absolutely isn't enough to talk only about biased data, data sets, algorithms. And if we do that, what we will do is locate the problems and solutions solely in the sphere of algorithms and data sets. Doing this, we would shift what essentially are political questions about the deployment of technologies into the domain of design, which is mainly dominated by commercial actors and technology companies. So all of this to say, I would say the first danger in this conversation about AI and discrimination is not to depoliticize the issue by focusing only on the technical nature of this technology. Instead, we really need to think about how do we shift that power, and also specifically on governance solutions. And I really hope later we can talk about what some of those governance solutions are. To sum up this answer, what I'd really like to say is that to the question of AI and discrimination is not really only about bad data and poorly designed algorithms. It's essentially how racialized people, migrants, queer and trans communities, the working class, people with disabilities, so all those groups of people that are already overly criminalized, monitored, discriminated against in many ways, will be likely to bear the brunt of harmful and more intense surveillance. And perhaps as we get into the conversation, we can talk about what some of those more harmful use cases are.
Thank you very much, Sarah. I'm sure we will touch on all of those things, but an hour is not a very long time, so I won't take up any more of it. Alejandro, tell me about the work that you're doing at the European Disability Forum in relation to AI.
Thank you very much, Jennifer. And first of all, I'd like to excuse the absence of my colleague Meher Hakobian, who couldn't be with us today due to a health problem that I'm replacing him today. So at EDF, the European Disability Forum, we've been working very closely with EDRi actually on the AI Act. I mean, we've been very active in the past on many of the flagship proposals from the Commission on the digital single market and all the digital files, trying always to ensure that the perspective of persons with disabilities, as you mentioned at the beginning, 100 million people with disabilities in Europe, 15% of the total population, are actually taken into account, because the way we design the technologies and also the use that we of these technologies actually define whether persons with disabilities will have actually the possibility of using this as a way to overcome the barriers that we encounter in our everyday life to access employment, education, public services, etc. That's why we've been very active in the past 10 years in ensuring that accessibility, for example, is a core aspect of the discussion around technology, along with privacy, security, and others. So accessibility is definitely one of the core drivers of our advocacy in this regard. And more particularly on AI, there is an additional challenge that we need to address as well, which is all the cases that we've witnessed of discrimination against persons with disabilities. Because in the case of AI, we see the both sides of the coin. We see the positive side, because we see that artificial intelligence is used to actually improve accessibility in many cases. We can see everyday examples such as automatic captions, for example, for video, which are very useful for those who are hard of hearing or deaf. We see also computer vision as well, which is very useful for those like who had a visual disability. So we see many uses of AI which are positive, but at the same time, we've seen how AI obviously discriminates those who are at the edge of society, those who do not comply with the kind of average user that the AI system is expecting, or the intended result that the AI system is seeking. So in this regard, we have working to ensure that persons with disabilities will have, or the deployment of AI will have persons with disabilities in mind, and will ensure that accessibility is incorporated. We are looking very closely, and this is very important, what uses of AI should be prohibited in the AI Act, and also how to ensure that there is redress mechanisms, and there is like the possibility for the communities to be involved and meaningfully consulted on what kind of uses of AI will be permitted in the EU.
Thank you. Indeed, Alejandro, we don't want to demonize all technology, and we're not anti-innovation when it's being used in the right hands for the right reasons. Although right now I'm not very happy with the manufacturer of Brando Benifei's device, because he's still struggling to connect. We will move on to Wojciech to hear from you, and the way that the EDPS's role in overseeing data protection rules can be brought to bear in this area.
Thank you first of all for possibility to be with you in the day which seems to be devoted to the artificial intelligence in many places. Not only here, there's another conference which is going on in Brussels as well. So quite a lot of things going on, and I have to say that I'm here in multiple roles, because of course I will be speaking as Data Protection Authority, also presenting the opinion which has been prepared both by the EDPS and my friends in the European Data Protection Board. So somehow I will try to present this very typical data protection approach, but also as an advisor to the Parliament and to the Council during the whole negotiation of this process, but also as a future regulator, because most probably, EDPS will be responsible for regulating the things. So I'm somehow thinking about my own role and the role of my successors in dealing with this topic. And what is also important, I'm a big fan of AI myself. And I would say that I see mainly the good uses of the AI, but as always, we have this margin, and that might be quite a big margin, which we should have a look at. And most of the things which we try to advise as far as AI is concerned is, first of all, ask ourselves, what do we really need to regulate, which was not regulated yet? Where are the gaps? Where are the white holes? What should be actually done? And the second thing, what should be the default solution and what should be an exemption? And that's the part which we are very keen on as far as any kind of discriminatory use is concerned. I'm very happy for what I heard today, that especially the civic society don't allow to be driven into the discussion about the bias as the only thing that is important. Of course, bias is something that we have to fight with, but we cannot only help to make the quality of the database and the resources better. Actually, what we should ask is, what do we want to use AI for? And these answers are not that far from the answers that we gave so far in another field. So AI then becomes one of the technological solutions, and the uses are actually the more important. So definitely we are not against the technology, and we may, however, ask what should be the default solution, what should be the exemption. And that's, for example, what happens when we think about remote biometric identification, which have been especially stressed in the opinion of the EDPS and EDPB. And I have to say that EDPS was quite pivotal in preparing this part of the opinion. Well, the use of the remote identification in public spaces is something which is important for us, but not public because of the ownership of these places, but publicly accessible. That's the most important thing that we are dealing with, because it's this is direct attack on the right to privacy and direct attack to the way that this society is actually built on. And the chilling effect here is absolutely obvious, and the mass surveillance is created in the most horrible way, actually, because we have to then think that wherever we are, we will be recognized, we may be recognized wrongly or rightly, in better or worse quality. And deployment of the remote biometric identification in publicly accessible spaces requires the setting the massive technical infrastructure. And once we start to build it, it will exist, and it will be like the wheel that we cannot actually stop, because we will invest, so we will want to see the results of that. Given that it's not possible to provide the sufficient safeguards at the moment, a blanket ban, in my own opinion, for this kind of use of the artificial intelligence for the remote biometric identification should be created. We can talk about exemptions. There might be situations where it makes sense to create such kind of biometric identification, but that should be exemptions from the general rule. So the social scoring, the emotional interference, maybe with, once again, with limited health purposes allowed, and biometric categorization that could lead to the unfair discrimination should be also banned, and that is what most of the opinion is then about. And the use of the AI in the field of criminal justice, law enforcement, migration, which were discussed at the previous panels, in our opinion, should be regulated very similarly as it is at the moment with the general AI. I also have several doubts about the changes that were done during the legislative process, though I have to say that the texts that we get from the Parliament and from the Council one after another are better than the previous one, which means that there is a big room for improvement. Yeah, so that the first proposal was not actually the final one.
Well, thank you, Wojciech. I'm sure when we come back to talk about exemptions, we'll make the point that they must be necessary, proportionate, and time limited. Brando, thank you so much for persevering and getting connected. We're talking about the AI Act today. Tell us a bit about what you're seeing, what's been happening in the IMCO committee, and where you expect further negotiations on the text to go.
Yes, thank you very much. I hope you can hear me. There were some technical issues, but and it's a bit precarious, but I hope you can hear me. So on the topic, I just came back now from the AI week of the Expo in Dubai, organized by the European Commission, and in fact I am having a lot of discussions and meetings with different stakeholders. I was earlier this month in Barcelona on the topic of the usage of AI in cities, and especially in the context that you well know of surveillance, biometric surveillance, which, as you know, is one of the hottest topics on which we are legislating. So the discussion is now going on mainly on these points. I will just list them. The definition of AI, which obviously will entail which algorithm will be included or not to be covered by the legislation we are now working on. Then the issue of the certification. Who will certificate? So can there be self-certification for all high-risk users, or should we have a third-party certification, especially for the most high-risk users, the ones regarding fundamental rights and family rights and citizenship rights and everything that is more and health and life. So to at least have some of the risk users that could be put under a third-party certification context instead of self-certification only. Then we have the issue of the prohibited users, which is a very delicate issue if we think of the biometric surveillance, the social scoring, and also I need to mention the chain of responsibility. Who is responsible when you have general purpose AI and when you have big multinational businesses that then have intermediate deployers, so medium-sized businesses or small businesses, and then the users? How are the responsibilities for the certification and for the respect of the rules be distributed? I mean, all these things are under scrutiny. We will work for all this year for having a parliament position with the rest of the parliament to find agreement, and then we will have to negotiate with the council. We know that especially when we deal with security and users that entail surveillance, we have very different views with the council already. We already know that. So we know there will be tough negotiations, but we are ready to work for that so that we can deliver a human-centric, trustworthy AI that, let me conclude on this, that can compete this ecosystem in Europe, can innovate not against our values, but with our values. So we are open also to have sandboxes and spaces for experimentation, for innovation that can be more free, but we want to be sure that we have a functioning legislation. So all the points I mentioned are important so that this doesn't stay just on paper, but it becomes an effective system, an effective instrument to, first of all, protect citizens, consumers, and all the vulnerable groups from risks of AI. Thank you.
Thank you, Brando, and I'm very impressed with your perseverance while you're on the move. Let's talk, we will come on to the issue of enforcement and how that's going to look. But before we get there, we need to have the right law in place. And Sarah, I'm interested to know whether, in principle, overall, you think that a risk-based approach is the right one. Sarah.
You ask me?
Sarah,
okay.
I'm asking Sarah. Can you hear me?
I can. Can you hear me?
Great. Yeah.
Thank you. Yeah, great. It's a great question. Can a risk-based system deliver the sort of fundamental rights protections that we want? So initially, civil society were really adamant that actually what we need to do if our main focus is protecting people, their fundamental rights, and particularly those of marginalized communities, what we really need to do is have that issue be the priority and have the scale of the impact or potential impact on fundamental rights be the determining factor of how AI is regulated. And we've seen that to some extent, especially we were very happy to see that there is a list of prohibitions of the most unacceptable risk AI systems in the AI Act. So you, to some degree, see the risk-based system working from a fundamental rights perspective. I think now the key question is, can a risk-based system deliver it on this? Is not necessarily only about the concept of a risk-based system. It's but what do you do when you classify something as high risk? And in two aspects, what are the obligations, particularly on, as Mr. Benifei says, on users of or deployers of high-risk AI, but also how flexible is the system? One of the sort of recommendations of civil society has been considering that AI is a fast-moving technology. There are many new systems on the market continuously, many of them tested, as the previous panel said, on some of the most marginalized in society, migrants, people with disabilities, racialized people. Then we need actually to have a system that's flexible enough to deal with these potentially new risky systems coming onto the market. And so currently we can only update we cannot update the headings of the high risk annex. We cannot update the types of high risk systems that are currently categorized in the Act. That needs to be changed and it needs to be modified so that we can do that in the future if an unacceptable or high risk type of system actually starts to being used. That's the first thing. The second thing is, okay, we classify a certain type of system as high risk. What are then the responsibilities on those using the technologies after that? Civil society have been really very clear that actually what the Act needs for it to be functional is some sort of system of obligations on the users or the deployers of high-risk AI. So pretty much all of the types of systems that we've been talking about here today in this entire event. If they are high risk, then there needs to be some governance mechanisms put in place so that users need to do a series of sort of accountability checks before that they are using these high-risk systems. And one of those particular specific changes that we could see is an obligation on users in the AI Act to do a fundamental rights impact assessment, outlining, okay, what are the potential impacts of the use of this system? Is there a risk of discrimination? And most crucially, how do we as a public authority or company using this high-risk system mitigate it? Crucially, that also needs to be transparent. So the details of that fundamental rights impact assessment should be shown somewhere, should appear perhaps in the public database that the AI Act already introduced. And that will be the first step along the way to ensuring accountability, but also empowering people affected by these high-risk systems to know and potentially challenge these systems if they need to.
Well, Sarah, since you're mentioning impact assessments, I'm going to jump to WatchEck because I know that just in the last couple of days, the EDPS and the EDPB gave an opinion on the extension of the COVID certificates. Now, while it's not specifically AI, I know you were very concerned that there wasn't an impact assessment carried out, despite that being a possibility. So is it enough to have good aspirations? How do we ensure that they happen in practice?
Well, as far as I know, this impact assessment will be provided. So this is not the, we just mentioned that at the moment when the opinion was done, it was not available. I fully agree with what Sarah said about the impact assessment, but on the other hand, maybe as a kind of joke, but unfortunately true as well, I can say that the best creators of such impact assessments will be artificial intelligence entities, artificial intelligence systems. Will have the special systems that will write this impact assessment the way that would be acceptable. So there is a problem here, definitely, because we can write the impact assessments, but they are not solution themselves. They are only the transparency tool that may help us to deal with the subject, but not necessarily the solution of the problem. Unfortunately, the solution is not also the certification. There is once again the problem which we will face in a few years, the bigger difference between the expectations of the users, but also the business and also the individual persons, that if they see the certification sign, the seal, which is attached to some system, then they can trust the system, and at the same time, the normal common understanding that the more flexible is the system, the more flexible is the connection of different algorithms which are used in the system, the less is possible to make the certification, because certification, even the best done, is done for the day today. And tomorrow, with the changes of the system and the changes of the algorithms which are in use, the system may actually produce completely different solutions. So I'm not saying that to say that there is no way out, but just let's not believe in silver bullets. Neither the impact assessment nor certification will solve the problem that we have to understand what is going on different levels, understand, be able to enforce, and be able to say no at the moment when we are not ready to take the real control over the tools that we create.
Well, you're painting a little bit of a dystopian image there of the future with the AIs writing their own assessments of themselves. So let me turn to you, Alejandro. Kranzberg's first law says technology is neither good nor bad, nor is it neutral. So let me put on my devil's advocate's hat again here and ask whether we're trying to blame technology for cultural shortcomings. Are we right to try and do that? Or perhaps if we're creating AI in our own image, it's not artificial intelligence we're creating, but artificial stupidity. Is it right to put all the pressure on the tech, or should we be looking at broader solutions? Explain to me why technology is the problem here.
Well, I agree with you. I don't think we should blame just the technology. It's also the decisions that us as society decide to make use of it for the specific for each specific circumstance or situation. So it's up to us to decide where we allow AI to be used. And do we want to either take the risk, high risk, low risk, to use AI in that specific domain or that specific use? I mean, at the end of the day, what AI pursues is to maximize results and to be more efficient. So do we want to, put all the efforts in ensuring that recruitment, access to education, access to to public services is as cost efficient, and we put all the tools at the disposal of this only and very important objective. This is a human decision that we as societies are making. And from the EDF perspective in this regard, for example, we do want to expand the list of the use of AI, including the AI Act, to other uses that are considered by the proposal as high risk, because we see that always among our community, we are the use of these kind of technologies is detrimental for us, and in that case, we would support the inclusion of in this list of prohibition, not only the biometric identification, but also the biometric categorization, the determination of individuals' access to education, recruitment, and those access services. So anything related to the people's opportunities to access essential services, we consider that AI should not be used in this regard. Maybe this is a very bold and very strong opposition to the use of this specific technology here. But in the case of recruitment, for example, we've seen in many cases that AI-based tools for recruitment are openly and actively discriminating against persons with disabilities. And we in Europe have the Employment Equality Directive that prohibits discrimination in the area of employment. Unfortunately, we don't have such anti-discrimination directive for other grounds. But in this case, I mean, it's a human decision, and our position in this regard is not to allow the use of AI in these key domains.
Brando, let me come back to you. You used a phrase I very much liked in your opening comments, the chain of responsibility. So let's have a look at one of the links in the chain. And I'd like to get your perspective on private companies or corporations and how much involvement they are having in shaping the AI Act, and whether or not it's going to become to them perhaps a cost of doing business, and that therefore enforcement may be difficult further down the line.
Well, I think we need to be realistic. Obviously, we need to have a cooperation of the businesses also for the act to work. But it will be crucial that the authorities that need to do market surveillance will be given enough resources to be able to check what's happening in the certification process, in the actual usage of the AI in our common market. And so it will be important to also have involvement of civil society, like the organizations that are involved in the debate of today, to monitor the development of the AI ecosystem. I think it will be crucial that we have also enough human resources devoted to this in the involved public administrations and authorities. This sounds obvious, but it's not. That there needs to be enough investment so that we have people with the necessary competences to deal with what they will need to do, to provide redress for consumers and citizens, and also to have a constant exchange with between the public institutions and the civil society that has been active on monitoring the development of AI, especially in respect to fundamental rights. We cannot risk that we ruin lives of people and we find out only too late, because it's true that also humans make errors and discriminate, but when it is a AI algorithm, this error and this discrimination can be multiplied to a very large scale. So we need to work in this sense.
Thank you. Sarah, you mentioned in your opening comments as well that a lot of tools and surveillance tools are tested on minority or discriminated against groups. But let's look at the flip side where, for example, these groups are actually left out of some of the decision-making process. For example, I was told a story recently about the racist tap. The faucet, because it was a sensor and they tested it and it worked perfectly well with all the engineers in the office. But then when a black person used it, it didn't recognize darker skin because no one had thought that it should maybe be tested and checked whether it was useful for everyone. If you look around Brussels, it's fair to say that the policymakers are a fairly homogenous group that are not very diverse. How do we get more voices into something like the AI Act at this late stage?
Yeah, great question. I think really about getting voices in, there's two ways. So one is, okay, how do we, from across the political spectrum, make sure that negotiators, MEPs, and members of all the different EU institutions are talking about a variety of civil society actors, but also people directly affected, exactly as we've tried to do with the conference here today. That's just a fact and needs to happen, not just in the creation of the law, but also in the standardization process, which us will see will have a very big role in the implementation of the AI Act, and also in a broader policy conversation about technology and digital rights in general. That's the first thing. The second thing is, okay, so when we're talking about to your point, Jennifer, about testing, the AI Act does give some opening. So we've talked about facial recognition systems. They have a number of potentially discriminatory sort of consequences, or other types of identification system having discriminatory consequences if they're used in certain contexts. The AI Act does, to some extent, give some sort of solutions in terms of debiasing those technologies, right? So we have earlier we heard from Yassine Aslam, who previously sort of worked for Uber and sort of supporting drivers, and he talked about the fact that a driver was deactivated from accessing that system simply because the technology couldn't identify him. Those sorts of technologies, not when they're used in the public space, but when they're used in other access to services, are kind of like categorized as high risk. And sort of the AI Act says, okay, they need to be properly tested with a representative group of people, including people of color. That's fair enough. However, back to the question of use, if we really want to sort of reflect the sort of harms that are impacting the most marginalized in society, what we have to do, and this is, absolutely crucial, is need to set out a framework, a comprehensive framework of all of the illegitimate and most harmful uses that are out there beyond what is currently in the Act. See the discriminatory impact, not just in how they're tested, but in terms of how they are used, and set the right red lines in terms of prohibitions. And what do we mean by that? What types of systems are we talking about? We've talked about facial recognition in the public space. It's a very strong and unified argument from civil society, and also outlined in the Reclaim Your Face campaign, which my colleagues have been really beautifully leading, to say that there should be a full ban without exceptions on facial recognition and other biometric systems in the public space. And we've seen that echoed by a number of the negotiators here today. Equally, in terms of predictive policing systems, we've heard from people affected that actually they have no use. They are basically predicting our activity before it even happens, challenging the presumption of innocence, and they are inherently racially discriminatory. They are discriminatory against people with disabilities and, of course, working class people. This also needs to be, we need to set the limits there. And equally, but without me having the time to go into it, as Alejandro mentioned, emotion recognition systems need to be in that debate around prohibited practices, biometric categorization systems, and as we've outlined, a number of risk profiling systems in the migration sphere. And I would say also, to add to that conversation, predictive analytics, especially when they're used to sort of prevent or combat this in a criminal way, this issue of irregular migration, which in many cases I would say poses a particular threat to the right to asylum, which we're seeing continuously attacked today especially in many cases of war across the world. So all of these things to say is we really want to include people in the debate, especially marginalized groups. We need to, number one, talk to them, but also we need to prioritize first and foremost, how do we combat, how do we prevent the harms that are most likely to infringe on their rights?
Well, we have a comment on our chat, and I will remind the audience, of course, to please do use that to put your questions to our panelists. Jerry Ellis has said that the AI Act should not just cover AI tools, products and services, but the products and services to which they are gateways. So I think this is looking at the trickle-down effect from the AI tools themselves. And I think that feeds in a little bit, Sarah, to what you were saying about where a technology is used as well as how it's used. And I'd very much, Alejandro, like your take on this, because, for example, you mentioned the bias in pre-screening CVs, but it may be that if we looked further along the line, there would have been points where this harm could have been headed off at the pass, as it were.
How? What would you mean?
What I mean is, if you've got the CVs and you're setting up your AI system to screen them, you might want to look at what the metrics you're using are, so that if you're asking the right questions and framing the debate in the right way of what sort of a person you're looking for, you might end up with better results, rather than simply the tool itself being the problem.
Yeah, no, definitely. I mean, the patterns you decide should determine also the outcome that you get. But in any case, what is very difficult is to gather so diverse potential aspects that will define this outcome of this model that will lead to selecting this CV and this not this other, it will be disregarded. So I find that sometimes it's quite difficult to comprehend in an AI system the full diversity of human beings. And that's the challenging that's the challenge there for the tech industry, obviously, and for the legislators now to decide on the AI Act, of course, because this problematic is also causing that, as I mentioned, like many times the efficiency comes first, and then there is the equal opportunities and fairness and so forth, which in the end, as we mentioned before, fairness is never ensured by even a single person, but obviously not in the algorithm that humans have designed as well. And what the comment from I believe Jerry Ellis said, I think is very important and relates very much with one of our core objectives in the work around the AI Act, which is accessibility. Because if we think of the Commission actually included accessibility as a voluntary thing that you can do for low-risk AI, but that's definitely not the approach and the mainstreaming that we expected. And now we've finally seen in other legislation, in the digital ID regulation, they did, in this case, the Commission, I mean, they did mainstream accessibility there, and they referred to the European Accessibility Act. So from our view, all the digital files should refer to the Accessibility Act requirements to ensure legal coherence, and that the tech industry knows what level of accessibility they should comply with. And in the case of AI, this is particularly important for IoT products, or even if you think of self-driving cars as well. So all these products that use AI should take into account at least a minimum level of accessibility requirements that ensure that not only persons with disabilities can use it, but also those as well who may use these technologies with assistive technology, and also to prevent potential unintended consequences. Think of, for example, virtual assistants and people with speech disabilities, for example, the complexity that these systems have to operate and so forth. So all of these are considerations that humans make in the design of the systems and the products that make use of these systems that should take into account accessibility. And for that, we are very clear with the allies in the European Parliament and with the Council that all these different files, the Digital Services Act, the Digital Markets Act, the AI Act, all of them, they should have the same level of accessibility as we have in the European Accessibility Act.
Thank you. And indeed, it's a point well made that it isn't simply about banning things or restricting things, that we need to also make sure that things are opened up to those who will benefit from them. Neil Heilgegger has asked a great question about transparency of the algorithm. Should the burden of proof be on the side of the business or the developer to prove that they do not discriminate? It's an interesting point. And Wojciech, where would you stand on that?
It's always a very tricky subject because we anyway have to remember that we cannot treat the people who are developing the AI system as the persons who are working against the humanity. So this is not as easy that we are moving the burden of proof in all the situations towards those who are creating that. So there are definitely the problems of liability which are to be assessed, and probably that was the biggest problem of the AI before the AI Act was created and the draft was created, and not necessarily the problems of deciding about the certification schemes or governance models for all this area. So I would not experiment too much. I would first try to set the principles and check how these principles are operating, because to change everything only because we think that we are meeting some dangerous technology is probably not the right approach. However, as I said, there are the limits that should be clearly set in the Act, and that's what the regulation is expected to be.
Thank you very much, Wojciech. Brando, I know you have to leave us very, very shortly. Did you want to have a final word before we say farewell?
Well, I think that that we started waters, in the sense that we are trying to do something that it has not been done in the rest of the world, just to have a really horizontal and encompassing legislation on AI. So it will take not just legislation to get our human-centric model through. We need to have investment. We need to have training. We need to have adaptation of our cultural and learning models. So it's a big challenge, but I'm sure that if we work together well, we can deliver in the interest of the citizens. Thank you very much, and see you all soon.
Thank you, Brando, and thank you for persevering despite some of the technical gremlins we've had today. We do appreciate your view. Sarah, let me come back to you with that question from Nick online, asking about where the burden of proof should fall in terms of whether it should be on the business or developer to prove that their products or services do not, or their algorithms in specific cases, do not discriminate.
Yeah, it's a great question, and I think the AI Act really tries to do that, exactly that, right? So it says in the sort of list of requirements on providers, they have to show that they have at least examined all the possible biases that are currently embedded into that system, which is a good step forward. In discrimination law, you have also the burden of proof to show not discriminating once it's like a sort of case, a prima facie case for discrimination has been made on the institutions or on sort of users deploying or public authorities that are using certain practice. And I think the same principle should be put into place for companies or public institutions that are using AI systems, especially high-risk AI systems, to prove that they're not discriminating. So this goes beyond the question of the technology developers, but also specifically who are using these high-risk technologies. The reason I say this is because in the AI Act, what we're trying to do is primarily regulate the technology developers. Now, this to some extent will maybe have some preventative extent in a general sense to potential discrimination that might ensue for the development of a particular high-risk technology. But technologies can be used in many, many different ways. And the requirements currently on providers will not do enough to sort of understand those various different context technologies, high-risk technologies will be likely to be used in. This is exactly why, going back to our question on obligations on users, we need two things. We need the users to prove that they are not, these systems that they want to deploy will not arbitrarily discriminate against people, will not disproportionately harm discriminated groups and any other types of people. But also we need sort of some sort of accountability. If there is a risk of discrimination, what will they do to mitigate those harms? So to the point of the European Data Protection Supervisor earlier, actually, yeah, fundamental rights impact assessments are not the silver bullet, but they are a step on the way to accountability. Having that accountability sort of on the table, put in a public database somewhere, then allows sort of this chain of accountability of people or civil society organizations who want to see where there are particular risks, see that there are particular harms on the table, to then look at this and challenge them if need be, which brings us to the very last sort of point that we haven't really discussed so much yet. There needs to be a framework in the Artificial Intelligence Act of rights and redress for people affected by high-risk AI technologies. Currently, there aren't any individual rights of affected people in the Act, and there should be. This is sort of the last sort of thread that isn't really explored. We have the obligations on providers. We have some acknowledgement of that there should be a limitation or a regulation on the use of high-risk AI technology, but we haven't got that framework yet for empowering people affected. And that needs to be the next step that negotiations should be exploring.
I wanted a follow-on question to you, Sarah, from Lina from Novak, Spain. I'm not sure whether you know, but has there been any link made between the AI Act and the EU directive proposal for business due diligence? Lina says it's very important to control the capacity of market-oriented companies, and traceability should be done beyond EU borders. This again puts the onus, I suppose, back onto the business or the manufacturers without really taking into account the context. Do you think it's an area worth exploring?
It's a great question. So there is some overlap between the proposal of civil society to have a fundamental rights impact assessment on high-risk AI and the sort of ongoing proposals in due diligence to say that there should be impact for companies in general. It's quite a technical question, but actually where we see that they don't overlap is that the AI Act covers many types of actors, so not just companies, but also public institutions that are looking to implement high-risk AI. That could potentially have a discriminatory effect. That's one distinction. And then the second distinction is that the fundamental rights impact assessment wouldn't be in general for the operating of an entire public institution vis-a-vis technology. It would be for a specific use case. So for example, if I were a public authority, I would be required to do this type of impact assessment before I would be deploying a particular system. Say if I wanted to implement a system that sort of analyzes and assesses people for their eligibility for social welfare, I would be required at that point before specific deployment of that system to do this exercise. And that's the difference between the due diligence proposals and this fundamental rights impact assessment proposal.
Thank you for that. Alejandro, to pick up on Sarah's point about redress, obviously, if you feel that the AI has been wrongly used against you, the right of redress becomes hugely important. But for those with disabilities, they may, for various reasons that are well documented, find it even more difficult to get redress. It's not at the hands of the average citizen, but it may be even further. So they will be doubly discriminated against. What do you think could be done to make redress within the Act a fundamental and easily achievable goal?
Yeah, that's a really good question. First of all, I believe the way to seek redress, in addition to being accessible in the format that you can raise your concern or lots of complaint. It should also be easy to understand, and I think that's one of the main barriers that persons with disabilities and older people as well face when using technology. The difficulty in understanding the process, the terminology, how to proceed, and so forth. So if we think of such a complex issue as, feeling that you've been discriminated by an algorithm or by an automatic decision, how would you proceed to seek remedies? And in this case, we believe that the AI Act should also provide for the possibility not only to lodge complaints individually, but also to ensure that there is the possibility to do collective complaints, like class actions that organizations supporting persons with disabilities or organizations of persons with disabilities can collectively take action if needed before the authorities that are established for that reason. But definitely the accessibility of this process, the understandability of it, and the possibility to do it collectively, I think these are three elements that we should take into account during the legislative process.
Wojciech, I'd like you to talk a little bit about, redress, and also perhaps bring in the idea about the exceptions that are foreseen already within the Act and how they would effectively remove that possibility of redress.
Let's start from general remark that we have to bear in mind all the kind of redresses that we already have. So, of course, as a data protection authority, I would say that adding any additional system of redress to the ones which exist at the moment in the general data protection regulation will not do anything good. It will actually even complicate the situation that we have at the moment. I think that most of the solutions that are right now proposed for AI exist already in GDPR for these data protection issues, for personal data protection issues. But if you go out of that and we think about the general governance of artificial intelligence that may help to get the real redress, then I'm very happy that I'm the data protection authority of the EU institutions, bodies and agencies. And I have 70 institutions that I have to deal with, because if I was the data protection authority on the national level and there would be the idea to give the right to issue decisions, guidelines, certification, and etc. To this entity on the national level, I would be really stressed and really horrified. At the same time, I know that the court redress, the redress which is done only through judicial system, will not be easy either. So that is the challenge which we didn't really met so far in the proposals given either by the Council nor by the Parliament. And exceptions, well, I especially mean the so-called pure scientific use and so-called general AI, general purpose AI. Well, I really have the big problem to find out where this general use is going to be finished. So I think any exceptions of this kind which are done are rather counterproductive. They will create the systems which will be hiding simply over these exceptions. And the same is unfortunately for the pure scientific use. I really don't know what does this pure scientific use may mean in this world. So let's be careful with exceptions. On the other hand, I can understand that exceptions may exist, but they should be narrowly defined. So even when I said that there might be a possibility to have the exceptions for the use of the biometric remote recognition in the public, the accessible areas, well, I can find the narrow exceptions, but then this data should be used only for this very defined purpose.
Well, and we should say it's not just the EU institutions, of course, that the EDPS has responsibility for, but also Europol. It's been in the headlines quite a lot lately.
So that's
An institution, but beyond
It's an agency. It's an agency.
An agency, but yes, but obviously one where there's a lot of these sensitive subjects coming up in terms of the personal use of data. Sarah, where do you stand on the question of redress? What Jake is saying, don't make it more complicated, and in that he certainly has a point, because it is a little bit beyond the reach of the average citizen in terms of, for example, what we've seen with the GDPR.
It's a great question. I think the crux of the concern of many people will be how it's a general question of enforcement, which we have with many digital pieces of legislation happening. So we have the ideal that needs to happen to empower people, and then we have a question of enforcement, like how can who would be the body that we receives complaints, particularly, and that's a key question that I think legislators really need to deal with. However, I don't think that it sort of prevents the need that there is there are potential set of sort of consequences that the AI Act brings for individuals, affected individuals, but it doesn't provide a way for individuals to be involved in this process, as Alejandro rightly outlined. So, for example, take the case of a social scoring system, which is banned under the Act. However, I, for whatever reason, have found out that I'm subject to the use of those systems despite that it's being banned. What rights do I have to enforce this ban? Currently, that doesn't exist. What we are saying is that there needs to be a right not to be subject to prohibited or uncompliant AI practices that the AI Act already outlines. And there needs to be a way that I, as an individual or as a collective, can address this. Looking for some of the most successful pieces of legislation that we've had, we see how the individual, these pieces of legislation sort of co-opt the citizenry into enforcement of these pieces of legislation. And that can be presenting problems for enforcement. It can raise questions of resources, but it is also the sort of the pillar of sort of like democratic involvement in digital legislation. So I wouldn't push away this question of redress. I think it's actually very key, and especially if we're taking the fundamental rights perspective. Beyond what is covered in the GDPR, there are a number of ways that our fundamental rights can be harmed by the use of AI that actually we don't have sufficient redress to be accounted for. So this has to be a really key issue, and how to involve the individual, involve affected groups, involve discriminated people in the enforcement of the Act. I think we need to pay attention of, and we should not brush away.
I'm also interested, we've only got 5 minutes left, and I don't want to open a whole new can of worms at this point, but what, very briefly, would effective redress look like? Is it monetary redress? Is it undoing the harms? Because in many cases, those harms may not possible to be undone. Is it an apology? I mean, these are the sorts of questions that I think perhaps if we had them in the Act to stop the problem before they started, it would be beneficial. Alejandro, give me your brief thoughts on that, as well as a kind of wrapping up comment.
Well, I guess it really depends on the case, right? So we cannot generalize and say that that all of them should have X, Y, and Z. I guess we need to look at the context in which the discrimination has happened, and just to wrap up, maybe to maybe stress again what we've been calling in this regulation is basically to guarantee that everybody will have the right not to be discriminated against by AI. And in that case, I just wanted briefly to mention that in the case of protecting the privacy of people, of individuals in this case, which may be, from some of our members pointed out, a flaw of the GDPR. Also, people under under total or partial guardianship. I'm very sorry about I couldn't substitutive decision making regime, exactly. So meaning those who are under guardianship that do have also the right to lodge complaints to protect their privacy when they feel that they've been discriminated. This is obviously fundamental for those persons with disabilities, particularly those with intellectual or psychosocial disabilities. And then again, the point on ensuring that the artificial intelligence will incorporate accessibility as a core aspect, along with privacy and the other objectives that we've been discussing today. Thank you.
Thank you. Thank you very much, Alejandro, and thank you for jumping in at the last minute onto this panel. Wojciech, a very, very short wrap-up word from you. Any key thoughts you want to leave us with?
I would stress what Sarah said before about the importance of thinking about the use of the technology, not the technology itself, and also the definition of the user, because we are saying on users, but we are defining them at the same time as those who use the deployed technologies, but also those who are the subjects of processing of the data. So let's be clear and let's be innovative, but let's remember that we are touching very, very delicate subject.
Thank you, Wojciech. And Sarah, the unenviable task of going last without repeating everything everyone else has said. What's your key message? I'm sure there will be policymakers watching this. What do you want to see?
I think really what we've seen today in this whole conference is that we currently see AI systems are being used in the service of power, in the service of discrimination, in the service of oppression. But actually what we really want to see is AI in the service of the people. And in order to do that, as we've all discussed today, we need the right prohibitions. We need a flexible enough AI Act. We need obligations on those using harmful technologies and obligations to prevent discrimination and harm. And also we need a way for individuals to be involved in this process and for them to be empowered. And these four things are really, I would hope, sum up some of the sort of points raised today by our speakers, but also are the priorities for policymakers going forward.
Well, thank you very much to all our panelists, both for this, our final panel, and also during the day, focusing in on the different issues, but all with that same unifying theme of imbalances of power and where AI sits within that. I'm going to hand over the floor now for closing to Claire Fernandez, the Executive Director of European Digital Rights Group, EDRi, who, of course, one of the organisers of today's event. Claire, I hope you have been informed, engaged, and really got to find a little bit more of nuance and levels in our different panels today, because we tried to break them out, and I had to say, we had excellent speakers. I'm sure you would agree with me there. But I leave it to you to draw those threads together and send us home with a message. We can't hear you. Try again. Are you on mute? You there? Can you hear me? Give me a nod if you can hear me. You can hear me, but we can't hear you. What we'll do is let's take a brief break for the video that we were going to show, and then we'll come back to you, Claire, and get your closing remarks after the video. Well, there was a video on the Reclaim Your Face campaign that is being spearheaded by EDRi. Claire, now I think we're back and all working well.
Okay, you can hear me now?
Yes, we can.
Okay.
Great.
Okay, thanks. As I was saying, thank you so much. And I did follow and enjoy really much the day. So I want to really thank all our speakers, including policymakers, for spending the time today to discuss AI risk, but really from the discrimination point of view. And today's event was really one of a kind in the type of EU policy, Brussels type of discussions we hear, where we really try to hear from people affected by discrimination, exclusion, and marginalization by centering their experience, not just in shaping the agenda of today's event. I hope that was apparent, but also shaping directly the way this act that will affect their life is being made. And I really hope that what we've heard today will show the vital needs to make adjustment to the AI Act. And what have we heard? I don't know if we answered today's questions as whether the AI Act can fix inequalities, but I think what was clear is that AI system can compound and reinforce existing societal inequalities, structural discrimination, and harms. And we've heard by people directly affected by the system, what I think Petra has called, the testing grounds of these systems, racialized groups, mothers of young children of colors. We've heard from people on the move, undocumented migrants, persons with disabilities, precarious workers, and working class. And it was really compelling to me to hear like Diana's testimonies about how children stand no chance in front of these robots and systems, or how Yassine mentioned about how these systems can destroy people's life and platform workers' life. I thought it was really interesting to hear also from Alejandro what kind of accessibility requirement from persons with disabilities are needed and are needed in these discussions. So what this experience and testimonies shows points to three clear avenues which were repeated in the last panels in the AI Act. First, it's clear that we need a greater centering accountability for the deployers of AI, fundamental rights impact assessment for all high risks of AI are clearly important, right? Not just thinking about the people making those systems, but the institutions, the users using these systems. Second, we need clear empowerment for the people affected by AI, not just from a data protection point of view, but there should be clearly and needs to for people affected by these systems and their rights to know that they have been the subject of AI systems and to have clear and accessible tools to complain and to challenge them. And then finally, we need a comprehensive approach to the prohibitions of unacceptable uses of AI, right, with no exemptions. Otherwise, we empty the whole protections, including the AI Act. And I think some of this unacceptable use have been very well described today, whether it's remote biometric identifications in public spaces, whether it's predictive policing, emotion recognition, and all uses throughout the migration control chain. So I really hope that this event can inform the rest of the negotiations in the Act and that we will continue amplifying those voices and centering people's needs in the AI Act. And I really want to finish by thanking all the organizers, in particular Sarah Chender from EDRi and Pamela Valenti from OSEPI, and of course you, Jen, and the whole Euractiv team. So thank you very much for making this possible, and thank you all for listening.
Absolutely, Clara. Thank you indeed to our audience for your engagement, for your questions and your attention today. It's a complex subject with many moving parts and one that's difficult to talk about when it's still in flux, but that means that now is the key turning point to maybe get some of those redress mechanisms, some of those safeguards in place so that we can help the most disadvantaged in society from becoming even more marginalised, which is, of course, the unifying aim of everyone who's been talking here today. So thank you for that. Keep up the great work. For our organisers, we know that you've got a lot of work ahead of you, and we appreciate today everyone taking the time to talk about this in the public sphere. So hopefully we can continue this conversation in the margins, online, with friends, with colleagues. Get everyone alerted to it, because this is something we'll be watching closely in the weeks and months to come. And with that, thank you very much. Do stay with Euractiv. We have many more events that you will find very engaging, very enjoyable, and hopefully you will be able to join us again soon. Have a great day.